Hello everyone. Now this is a sample lecture that I've recorded for Mains Magna Carta 2024. Now this lecture is for Mains 2024, but because the topics are so substantial, it is relevant for anybody who wants to prepare for the mains at any given point of time. The notes required for this lecture are also uploaded on the Telegram channel. When you watch this lecture, I know this is a long lecture, watch this lecture keeping the notes handy that I have uploaded on the Telegram channel. And this will teach you not only substantive parts of the topics that I've covered, fundamental rights, directive principles, but will also give you a very clear-cut insight on how to analyze previous year questions for the mains. So anybody who is preparing for the mains at any given point of time, I purposely chose this lecture because this lecture is the perfect combination of static and current, and no matter when you're writing the mains, this lecture would prove to be of some benefit to you. Thank you so much, and please enjoy the lecture. Thank you. Hi, and welcome to lecture number 2 for the Magna Carta for the Mains 2024. Now, in this particular lecture, we're going to be covering 4 topics which are mentioned indirectly in the main syllabus. We're going to be covering the preamble, fundamental rights, directive principles, and fundamental duties. Now, let's go back to our fundamentals. In the orientation lecture, I had walked you through the general idea that we're going to be following as far as the Magna Carta mains for 2024 is concerned. We will first look at a correlation to the syllabus. Then we will understand how it gets mapped to previous year questions. Then we will cross-reference it with current affairs in terms of how they're asked, and then we will have a short list of topics that we need to prepare as far as the exam is concerned. Now, let's first look at what exactly in the syllabus are we going to be covering. First things first, when I look at the syllabus, the words preamble, fundamental rights, directive principles of state policy, and fundamental duties, none of them are actually specifically mentioned in the syllabus, which means they are not explicitly mentioned in the syllabus. Does that mean we ignore them? Of course not, because they are vital to understanding polity and the constitution in general. This means that they are implicit as far as the syllabus is concerned. If they are implicit, then we must also understand how exactly are they implicit. First things first, there is something called important features. Then there is something called significant or important amendments. Then there is something called the doctrine of basic structure. And on the explicit front, you will find basic structure mentioned, and you will also find separation of powers mentioned, wherein basic structure, translating into judicial review as one of the components, has a key impact on separation of powers and thereafter checks and balances. So, although a topic which is not explicitly mentioned in the syllabus has 4 correlations to our syllabus, and therefore we have to make sure that we do this in the appropriate manner. So this particular set of 4 topics is both implicit and explicit. Explicit on 2 counts: 1, basic structure, and 2, applications of separation of powers. Implicit on 2 counts: important features and important amendments, because some of the most significant constitutional amendments are actually owed to preamble, rights, directives, and fundamental duties. So we shall keep that in mind. Now, We will cross-reference it with PYQs and we will see whether or not they've been asked because of a certain reason. We'll also check how frequently they're asked, and we'll also check to what context are they asked. And to answer this more carefully, we will cross-reference it with current affairs and check, was something that occurred in the same year as the mains calendar or a year before the mains exam triggered that question to be asked? Was it something which was generally in the news for a longer time, or we were celebrating an anniversary or a monumental year or 5, 10, 15, 20, 25-year old anniversary, which is why it sort of becomes important. So we shall keep that in mind, and we will therefore draw a relevancy matrix or a topic relevancy shortlist, which we will follow. Now, this particular lecture will have to be divided into two parts because there is a significant amount of things that have to be covered, largely because on an average, you see anything between 1 to 2 questions being asked from here directly in the mains exam. And not only this, some of the key learnings from these topics are correlationally important to your other GS papers and also contextually important to your essay. So this in fact happens to be one of the most open-ended and also happens to be one of the most diverse areas that we have to cover. देखो कहने की बात यह है कि ये एक बहुत ही हाई रिवॉर्डिंग टॉपिक है. ये हमें पता है कि 1 से 2 क्वेश्चन तो आएंगे ही आएंगे, और एक क्वेश्चन अगर बेसिक स्ट्रक्चर से है तो दूसरा राइट्स इशू से भी आ सकता है, और ये कई बार आया भी हुआ है. बट इसके अलावा क्योंकि राइट से राइट्स इश्यूज निकलते हैं, वो आपके पेपर 1, पेपर 2 तो हम कर ही रहे हैं, पेपर 3, पेपर 4 और essay में भी बहुत काम आते हैं. Which means we have to be a little precise, we have to be a little more comprehensive at the same time to cover what is to be relevantly done as far as the mains exam is concerned. So let us look at what kind of questions have been asked. थोड़ा इसको आराम से करेंगे, थोड़ा ठहराव से करेंगे. Not because of anything else, because if you also learn the science of PYQ deductions, so you will be able to apply it to other subjects, you will also be able to apply it to other papers, and you will also be able to cross-check whether what we are doing is actually making sense or not. So it works in multiple number of ways. Now, there are 4 topics: preamble, rights, directive principles, and duties. And we've understood that these 4 topics are asked directly and indirectly, standalone and otherwise. So let's break them up and let's look at first the preamble. Now, in the last 10 years, there has just been about 1 question from the preamble, and that was in the year 2016. And the question categorically stated, it's right up here: discuss each adjective attached to the word republic in the preamble. Are they defendable in the present circumstances? Now, the first mistake most people would do is they would not read attached to the word republic, which means if you look at your state-centric adjectives, it is sovereign, socialist, secular, democratic, republic. What the exam is asking you is only sovereign, socialist, secular, democratic, but not republic. The trick part is, are they defendable in the present circumstances? Which basically means, are we sovereign? Are we socialist? Are we secular? And are we democratic? Of course, this could be answered in a fairly good manner. There are enough and umpteen examples that could be given. Basically, this question has to be done through a subdivision method. A simple subdivision method is break the question into smaller questions. So you'd say, for example, sovereign, the original meaning, the transition of the word sovereign, the updated meaning, the reasons for transition, and what does sovereignty mean for India in the contemporary context, which would, for example, mean national interest. We would cover something simple, similar to this in Magna Carta Mains 2024, and I'll tell you why. So let's first look at why this question was asked. Now, the preamble has had 1 amendment till date, and this amendment was done in 1976. And the UPSC loves their anniversaries. So 40 years to the 42nd Amendment of 1976, you had a question on the preamble. Now let us apply it and see, is this relevant for mains 2024? So irrespective, because you have such an interdisciplinary usage of something like the preamble, maybe a direct question on the preamble is unlikely, but having a one pager covering the legal status and the utility and meanings and applications of key terms will not hurt. And if they can ask you the preamble, they can also ask you a stand-alone question on what is the utility of directive principles. Why do we even have fundamental duties? Do they make any sense? They probably give you a quote around it and ask you to explain the quote. So, not the most important, but should definitely be done. So we will do this in lecture 2.2. We're on lecture 2.1. It's not highest priority, but just to keep our boxes tick, we will definitely do this in lecture 2.2. Now, that's pretty much it as far as the preamble is concerned. Now, we move to fundamental rights. Here you'll be able to make a lot of very, very educated deductions. Almost every year, barring maybe one or two odd instances, there has always been a question on fundamental rights. So in 2013, the question was, discuss section 66A of the Information Technology Act with reference to its alleged violation of Article 19 of the Constitution. Now the reason why this question was particularly asked was, section 66A was in the news in a transient form because of certain very, very questionable instances. There were two girls who were arrested in Bombay because of an objectionable post that they had made on Facebook back in the day, and Facebook used to be cool. The post that they made was regarding the shutdown in the state of Maharashtra because of the death of a very, very well-known political leader in the state of Maharashtra called Bal Thackeray, and therefore they were arrested under provisions of section 66A of the IT Act. In continuation of that, Asim Trivedi, if I'm getting the name right, was a very well-known cartoonist who had made certain political cartoons and therefore was arrested under grounds of section 66A, and the judgment was pending. And even if you today don't know when the judgment was, if you read the text of the question, it tells you with reference to its alleged violation, which means the question is not being asked post the Shreya Singhal judgment. So this teaches you 2-3 very important things. First, Article 19 is a highlight. 2, if the Supreme Court judgment is pending, that means your opinion on the issue would be asked. If the Supreme Court judgment has been delivered, then generally your impact is asked. I will prove this theory when we look at the right to privacy question of 2017 just in a few moments from now. And that teaches you a very, very important insight. So this is the question. Thirdly, and very importantly, while the context can be political or controversial, the question rarely ever is. The question is going to be very straightforward. You're supposed to answer an apolitical and a neutral answer to a question which has been inspired from politically anxious circumstances. And the idea therefore is to test your ability to write an answer as a well-informed citizen of this country. So while trigger events such as these can prompt a question like this to be asked, the question will never be on the trigger event. The question will not be ever on that specific political issue. And that's a very, very important insight to have, which is also why you've never been asked your opinion on reservation. You've never been asked your opinion on something religious. You've generally been asked an academic question. never a question on a specific incident which was controversial, political, or objectionable in nature. So we'll keep that in mind. Now, 2014, that itself gives me a heads up that it is an election year. Now let us read the question carefully. What do you understand by the concept freedom of speech and expression? Does it cover hate speech also? And why do films in India stand on a slightly different plane than other forms of expression? Now, there is too much being asked, but there is a common thread to it all. Of course, the first thing being it's election year. But always remember, the longer the question, the easier it is to structure the question. It is easy to structure a question because the structure to the question is already mentioned in the question. Even if you divide your question into 3 parts and answer, first heading, meaning of speech and expression, second, relationship with hate speech, and third, treatment of films, that itself is a fantastically brilliant structure which is absolutely good as far as the examiner is concerned. And now when you look at the reason why this question was asked, it's even more enticing. There was a lot that was going on. First, of course, as we mentioned, it was an election year. Second, election years are infamous for questionable speeches. Questionable speeches that often tend to cross the line. Questionable speeches that can often be very dangerous in terms of caste or religion. And when the speech is targeted to a specific community, that form of speech is called hate speech. Now, hate speech instances will always rise up in and around elections, whether it is a national election or a state election. But generally it is national election which brings hate speech into the forefront of things, which is why it's asked in the context of what is called the election year. But also, just a few months before, you had also suffered from what were called the Muzaffarnagar riots. At least in the past decades, in the past decade or so, not decades, at least in the past decade, Muzaffarnagar riots have been one of the deadliest insults to law and order and civic behavior in the country. And therefore, the reason Muzaffarnagar riots happened, and they were communal riots, were because of certain inflammatory speeches that were delivered which had an impact beyond imagination. Thirdly, it also celebrates approximately 100 years of Indian cinema. The first silent film goes back to that date. And the censor board was brought into the fray of things because of very, very questionable decisions it had taken on a film which was very well liked and had in fact a lovely message embedded in the film. The film was called PK. And at the back end of things, the leadership of the censor board was undergoing some changes in terms of appointments which were allegedly to be biased for the ruling dispensation. And also the censor board, in terms of its functioning, was also questioned by the CBI for the lack of transparency. So one could definitely say that this question had a trigger event. This question had a floating issue of the censor board, the trigger event being the hate speech. And at the very same time, this question very categorically never ever mentioned the instance, but asked you to answer this question rather apolitically. And if you see, the thread continues. We are still on Article 19. You have still been asked an apolitical question out of a political or a controversial issue. And at the same time, you've been asked a question in a purely academic fashion. So by now we can very categorically determine that Article 19 is indeed a UPSC favorite, and especially during election year, which automatically makes it a sort of a green flag for us as far as means 2024 is concerned. Now, 2015. Does the right to clean environment entail legal regulation on burning crackers during Diwali? Discuss in light of Article 21 of the Indian Constitution and judgments of the Apex Court in this regard. Now, after 2 years of Article 19 questions, we see an Article 21 question. Now, the judgment has not been delivered yet, which is why you have been asked your opinion on this pending Supreme Court judgment. It is in this very judgment, by the way, where the Supreme Court has actually given out a clear-cut direction and a clear-cut set of regulations which said that we will not outright ban crackers in Delhi, but we will impose a very high degree of terms and conditions on how crackers are to be burst in Delhi, which basically means crackers beyond the decibel value are not permitted. Crackers which cause pollution beyond a certain limit are not permitted. Crackers beyond a certain time limit are not permitted. And this essentially creates a conflict within rights. And conflicts of rights between each other is a UPSC favorite. So on the one hand, you have the right to a clean environment, which has also been sort of derived by the Supreme Court as an interpretation of Article 21. At the same time, you have the right to life, and you also have the right to celebrate your own festivals as an extension to that right to life. You could also implicitly put in a little bit of Article 25, because if people are burning crackers during Diwali, it is also one of the ways that you are in fact celebrating a religious festival. And it's not just during Diwali that crackers are burst. In fact, crackers are burst across different festivals, across different religions. So the idea here is, this was in the news a couple of months before the mains. The judgment was pending, yet was important enough to be in your mainstream newspapers for us to be a little careful about. So now, in addition to Article 19, Article 21 becomes a UPSC favorite, and we'll see how in a few questions from now. And we started with a thesis which was that if the Supreme Court has delivered a judgment, then what you would be asked is the impact of that judgment. What you would be asked would be the consequences of that judgment. And you're able to see this categorically in 2017. And in 2017, the question is, examine the scope of fundamental rights in light of the latest judgment of the Supreme Court on the right to privacy. And this is, of course, the Puttaswamy versus Union of India judgment of 2017. Now, the judgment was delivered before the mains exam, which means you're not going to be asked whether you think right to privacy should be a fundamental right or not. The question is very categorical on this. The question asks you, now that we have right to privacy as a fundamental right, what do you think it will lead to? What are its impacts? And therefore, you would look at its impacts on informational privacy, on data privacy, on body privacy, on physical privacy, on financial privacy, and so on and so forth. The fact that we have right to privacy as a fundamental right itself becomes a catalyst for several socio-legal reforms. In fact, one of the primary reasons why we were able to decriminalize homosexuality in the Supreme Court judgment of Navteej Singh Johar versus Union of India is because the petitioners were able to argue that now that we have the right to privacy, and bodily privacy is an integral element of privacy, we would like for people of the same gender to be allowed to be intimate in a private sphere nonetheless. And it would therefore be arbitrary to have sexual orientation as one of the grounds preventing people of the same gender to be intimate in a private capacity. And therefore it is not just arbitrary, it is also not reasonable, because it violates the principle of intelligible differentia and rational nexus and intelligible differentia. So therefore, the fact that the judgment has been delivered makes this actually a law and a policy question. And of course, it's Article 21. So up until now, we've got two questions on Article 19 and we've got two questions on Article 21, which means you have to prepare 19 and 21. And if you see, there is a certain repetition, sort of a frequency matrix. If they've asked this 2 years, then they'll skip and they'll come back after 2 years. This will help us a lot, because in 2023 and in 2022, there were a bombardment of questions directly and indirectly on Article 21, which means Article 21 for us in 2024 will be of a slightly low priority than perhaps Article 19. So we'll keep that in mind. And because of the fact that that 2024 is also an election year, also notorious for certain elements related to speech and expression, Article 19 becomes all the more important. So for 2024, to the best of my understanding, Article 19 would therefore be more important than Article 21 because of frequency, because of context, and because of dimensions. So we must keep that in mind. Now, if you take a moment and just look at the questions before you, you would also understand that from a theoretical point of view, none of these are dimensions that you would have not thought of. When you do Article 21 theoretically as a part of your foundation courses, or when you study it on your own, when you're preparing it not right before the mains exam but generally for UPSC, you would have prepared privacy and you would have prepared environment as two of the most important aspects of Article 21. Similarly, when you study Article 19, censorship and forms of media and dissent related issues such as protest, strike, hate speech, and sedition, which now today is far wider and far deeper because of Section 150, 156 of the new IPC, where punishments are also a little more strict, which has just come into effect from the 1st of July 2024. But these are very legitimate, very, very logical and very, very theoretical boundaries to Articles 19 and 21. So we must keep that in mind. Now, 2019. This is where there's a little bit of sprinkling of comparative constitutional law. Now, comparative constitutional law has been asked twice with respect to this topic. One has been with France and secularism, and the second has been with US and equality. So, in fact, when I look at a syllabus correlation, I also understand that there must be some reason for me to be very, very careful about when it comes to comparative constitutional schemes. But comparative constitutional schemes have to be prepared with a very high degree of context when it comes to these topics. Let's understand why that is the case. So, in 2019, the question was, what can France learn from the Indian Constitution's approach to secularism? First, you've identified France. Now, secularism, of course, is in the preamble, is reflected in fundamental rights, also has intersections with directive principles in the form of Uniform Civil Code, and also has some reflections in fundamental duties in terms of having a scientific temperament and, of course, living in harmony and so on and so forth. Now, why France and why 2019? As you would know that France had banned women of the Islamic faith in France to wear something called a hijab. Now, the burqa is an all-body outfit, whereas the hijab is something that covers the face. Now, under Islamic faith, Islamic women who are ardent followers of the Islamic faith tend to keep the hijab. Now, the French government, some time ago, before 2019, had actually banned the hijab. Now, what happened in 2019 was they made an amendment to the hijab law and therefore said that women who are mothers accompanying their children, even for school trips, will therefore not be allowed to wear a hijab. And this became a rather questionable exercise, because if your grounds for banning the hijab was security, a mother accompanying her child on a school trip cannot be a grave security concern to begin with. So that caused a lot of protest. Second, though this was incidental in nature, but one of the most well-known landmarks in France, called the Notre Dame Cathedral, was also burnt. Now, it was not done because of communal reasons, but it was incidental in nature. But it is also around the same time that several Jewish temples in France were also attacked. Now, if you look at it, there are basically three countries that we get asked questions on. We get asked questions on US, UK, and France. Now, 2019 teaches you something very important. There has to be a context and there has to be a significant comparative difference. When we look at the models of secularism between India and the West, when we look at the debates on secularism between India and the West, France tends to be that country which has dealt with secularism in a very, very unique way and in a very stark way as compared to how India has. The Indian version of secularism and the US version of secularism are, of course, very different, but are not as poles apart as what India and France is. So, therefore, if secularism had to be asked, A, there had to be a global event around it, and two, the country that you would naturally ask a question on secularism would be a country called France. And that is why in 2019 there was a question on secularism and France. Now, this is a comparative constitutional question. You have to know a global event. Now, let's take a minute here and think. In 2024 and perhaps the second half of 2023, there hasn't been a major global rights movement. There are two major issues that have come to the limelight, and that's been from the US. One has been an issue of how the US, through the Supreme Court, has scaled back sort of racial affirmative action exercises, basically reservation for African Americans at higher educational institutions in the US. And two, the US has also scaled back its stance on pro-abortion rights. Now, pro-abortion rights are too specific to be asked. Even comparing gender rights between India and the US is too specific to be asked. And the last question that was asked on comparative constitutions was between India and the US on equality. And affirmative action is an aspect of equality. In fact, what we have is called the form of equality that we have is called egalitarian equality. It's a combination of substantive equality and formal equality. And our notions of egalitarian equality, which combines the principles of equality, equity, and justice, are in fact one of the finest in the world. But that's besides the point. The point is, the US was just asked, and the question was on equality. So even if there has been a major issue with rights pertaining to equality in the US, it still doesn't make it relevant enough for Mains 2024. And that's the kind of discretion and that's the kind of a hard footing we must operate on, because A, time is finite, and B, memory is even more finite than time. Now, in 2021, analyze the distinguishing features of the notion of equality in the constitutions of US and India. And this is, of course, applies the same logic in the context of the Black Lives Matter movement. Now, for a question on gender and affirmative action to be asked again in the context of US seems extremely unlikely, especially in Mains 2024. So therefore, as far as Mains 2024 is concerned, and if you think about it the other way, we're in fact witnessing elections in the UK. We will be witnessing elections in the US, which means there has to be one question on comparative constitutions. And if there has to be one question on comparative constitutions, think like the paper setter. Would you rather not have a question comparing presidential and parliamentary systems like you asked before? Or comparing parliamentary differences between the UK and India? Because of course we are a model, but we are also distinctively different from the way the UK operates. Given the fact that all the three of us have elections on our plates. We've just finished ours, UK is in the process of theirs, and the US is going to get into elections in a few months from now. So for these very reasons, if there's going to be a comparative constitutional law question in Mains 2024, it's going to largely be on political systems and their differences between either India and the US or India and the UK. So we'd rather prepare that than to waste our time on comparative constitutions as far as rights are concerned. This is a very logical way to go about it. Now, 2022. So equality is Article 14, 2022. The right of movement and residence throughout the territory of India are freely available to Indian citizens, but these rights are not absolute. Comment. Again, we see Article 19 as a showstopper. We again see a completely apolitical theory question. And let's understand why this question was asked in 2022. 2022 is where we've been in the midst of the pandemic. We've seen multiple waves coming in. And one of the first things that you would do when the country and the world hits a pandemic is enforce a lockdown. And when you enforce a lockdown, and we did that under provisions of the Disaster Management Act and the Epidemic Diseases Act, and one of the first things that you would do is enforce a lockdown. And this would directly impact your freedom of movement. On top of this, because of heightened protests in and around developments with respect to the Citizenship Amendment Act of 2019, and of course the farm law protests which were at its peak, where you had almost seen an instance where the National Capital Region of Delhi was chock-blocked from all four corners, preventing any exit or entry from Delhi, almost making the capital come to a standstill, with of course excessive violent protests reported in and around and inside Delhi, which would of course lead to certain curfews, certain provisions of the CRPC which will now be revamped to be put in place. And also at the same time, you are also witnessing the Assam-Mizoram border dispute. Now, this is triggering, but at the same time, it is floating. There were a series of isolated events all through 2024 which led the government to enforce restrictions on the movement of the people. As a result of this, you had to therefore invoke provisions of Article 19. And that is why the question in 2022 was asked. And again in 2022, environment has been asked before, and environment has been asked in the context of 21. We see an environmental question again in 2022 pertaining to Article 21. The question is, the most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with the help of relevant case laws. Now, this is an anniversary question. And whenever there is an anniversary question, the question will always be very reflective in nature. The question will always be very encompassing in nature. The question will ask you to sit back and think, are we happy where we are today? How did we get here? Has it really helped? What has generally been the state of evolution? Now, environmental law in India is generally understood to be reactionary in nature. In fact, most of the doctrines that we have evolved in environmental jurisprudence have been because of Supreme Court judgments. Which is why, after the Stockholm Conference in the 1970s, the Bhopal gas tragedy is often considered to be a watershed moment in environmental jurisprudence, which eventually led to the Environmental Protection Act. But whenever you look at some of the core environmental doctrines that have been evolved, they have always been evolved by the Supreme Court. In fact, environment has played a very significant role, not just in environmental jurisprudence, but rights jurisprudence in general. It is because of evolution of the rights of environment, you see a wider meaning of Article 21. You also see an enhanced usage of public interest litigations. You also see usage of the Supreme Court's powers to take up cases suo motu. You also see fundamental rights which are traditionally available only and only against the state to also be available against private institutions because they are the chief polluters of the environment. And fourth, of course, you see the conceptualization of certain environmental doctrines. Now, these environmental doctrines, as we understand them to be, are, for example, sustainable development, polluter pays, the precautionary principle, the public trust doctrine. And all of them are credited to a very select few number of environmental cases. We've had very few public spirited lawyers who have constantly filed cases after cases in almost the same amount of time, thereby leading to a same 25-35 year plus minus one anniversary setup. Which is why MC Mehta, Vellore Citizens Forum, Rural Entitlement Kendra, they're all in the 25-35 range. Which is why in 2022, there was a question on environmental jurisprudence. Now, this means it is very close to 2024. And we have a frequency pattern to keep a note of. And if Article 21 appears in 2023, which it will, it automatically reinforces the idea that we don't have to do it any more further as far as 24 is concerned beyond the basics. So we'll remember that. So 2022 is again environment aspect of Article 21. Now, 2023. Two questions, very open-ended, but again, for very simple reasons. The question is, the Constitution of India is a living document with capabilities of enormous dynamism. It is a constitution which is made for a progressive society. Illustrate with special reference to the expanding horizons of the right to life and personal liberty. Now, one of the first things I'd request you to do is, don't get afraid by the framing of the question. Always look at polity as a comprehension English exercise, where your job is to simplify what the question has asked. The Constitution is a living instrument with capabilities of enormous dynamism simply means the Constitution is capable to change. The Constitution is flexible. The Constitution can evolve. And the Constitution is made for a progressive society means the Constitution evolves keeping in view the changes in the outlook and the aspirations of society. Illustrate with special reference to the expanding horizons of life and personal liberty. Now in 2023, the reason why this question was asked is because the most significant judgment which had an enormous impact on Article 21 was also a slightly odd question in 2023 in the prelims also, was Maneka Gandhi. Because in Maneka Gandhi versus Union of India in 1978, what had basically happened was, the Supreme Court said that though Article 21 says procedure established by law, it also, through an implied meaning, includes what is called due process of law. Now, what the Supreme Court meant by due process of law in Maneka Gandhi's case was procedural due process. So, Article 21 included life and personal liberty which could be restricted by procedure established by law. Because of Maneka Gandhi, the Supreme Court interpreted it to be due process of law, but from a procedural standpoint, which means not only should the procedure be valid, the procedure must also be good. And for you to check how the procedure has to be good, you would apply the principles of natural justice. This was 45 years ago in 2023. And that is why this question was asked. So this question basically gave you an open hand to tell me how exactly has Article 21 evolved over a period of time. Environment, right to life, therefore means right to dignified life, therefore means right to death. It also means due process of law. It also means privacy. It also means a host of other things. So the idea, you could organize it in a certain way. You could take life, give me interpretations of it. Personal liberty, give me interpretations of this. Do a thematic understanding of environment and privacy all over again. and throw some light on due process of law. And that's your answer for 2023. The longer the question, the easier is your structure, because the structure is embedded in the question. So this was why 2023, again, an anniversary year, therefore had a reflective question. So 2024 should be an anniversary of what? The greatest judgment which comes to light in 2024 is S.R. Bommai of 1994, which has nothing to do with fundamental rights per se. Has an implication, but nothing strongly to do with fundamental rights. It's a combination of a host of other things, including emergency and federalism. We're witnessing 5 years to Sabrimala. We're also witnessing 10 years to the Nalsa judgment. But both Nalsa and Sabrimala have a very limited capacity to be asked, and I'll show you how. Simply because in 2023, if you read the question, explain the constitutional perspectives of gender justice with the help of relevant constitutional provisions and case laws. Now, if this question has been asked, that means there has to be a trigger event, again an anniversary year. Basically, 5 years to the Triple Talaq case, the Shaira Bano case, and Uniform Civil Code in 2023 was also in the news because of certain speeches that were being made, and there were also talks about several states pulling in and therefore thinking of coming up with the Uniform Civil Code. In fact, the Uniform Civil Code is also important this year because Uttarakhand has tried to enact one, and therefore there will be some amount of importance on that front. Having said that, there has been a question on Uniform Civil Code when we were celebrating X number of years to the Shah Bano case, and I will discuss that question under the DPSP section, but mostly because of anniversary years. So we have to keep a track of these things, which of course we are as far as your mains 2024 is concerned. Now, this question in 2021, I know 8 out of 10 students who attempted this purely from a fundamental rights perspective. Rightfully so. But remarkably, this question, although is about fundamental rights, but is also about so much more than fundamental rights. Constitutional morality is rooted in the Constitution itself and is founded on its essential facets. Explain the doctrine of constitutional morality with the help of relevant judicial decisions. Now, why would this question in 2021 be asked? And this is a cumulative question, which is why I kept it as a special question later. Because A, petitions were filed challenging the amendment to the Citizenship Act of 1955. The amendment was made in 2019. A petition was also filed challenging the abrogation of Article 370, which has now been decided by the Supreme Court in 2024, and the abrogation of Article 370 has been upheld by the Supreme Court. Petitions were also filed to entertain a review of the Supreme Court judgment on Sabrimala. And there were also issues of a federal conflict between the Lieutenant Governor of New Delhi and the elected government of Delhi headed by the Chief Minister. And all of these things have constitutional morality in common, as argued in the courts, as discussed in the courts. See, constitutional morality has two aspects to it. One, where in the Constitution is the word morality explicitly mentioned? To the best of my memory, the word morality in the Constitution is mentioned in 4 places. Twice under Article 19 and twice under 25 and 26. So constitutional morality therefore means 2 things. One, where in the Constitution is morality explicitly mentioned and how? And in all the 4 places, morality is mentioned as a reasonable restriction to fundamental rights. And secondly, even though in places morality is not mentioned, the Constitution itself is a moral document. So if the Lieutenant Governor of Delhi does not want to listen to the advice of the Chief Minister of Delhi, who is heading a democratically elected government, you are violating the very moral compass of the constitution that it set out to be, which is effectively to empower parliamentary democracies. So that is the context. Anyway, 2023 was also an Article 21 question with a little bit of Article 15 involved, but primarily an Article 21 question, which is why in 2024, if there has to be a dedicated rights question, given the fact that it's an election year, given the fact that speeches go haywire, you should be looking at an Article 19 question in mains exam 2024. Because aspects of privacy, evolution of Article 21, all of that has been asked rather too recently, thereby making Article 19 the flag bearer for core fundamental rights for mains 2024. Now, some special questions. We've discussed constitutional morality. This question, though has origins in fundamental rights, but actually is a bodies question, which has intersections in governance and polity and social justice all together at the same time. Let us understand how and why. In 2018, the question was whether the National Commission for Scheduled Castes can enforce the implementation of constitutional reservation for scheduled castes in religious minority institutions. Explain. Now, if you think about it, the question is actually not about reservation. The question is about the mandate or the powers of the National Commission for Scheduled Caste. And the reason why this question was asked in 2018 was because both of the religious minority educational institutions which are centrally funded, the Aligarh Muslim University and the prestigious Jamia Millia Islamia, both had denied reservation to students of the SC community, as an outcome of which petitions were also filed. So this question was not about the idea of reservation, and our original thought remains to be the same. While reservation is a contentious issue, while reservation is a controversial issue, while reservation often realms into a political arena, the question that has been asked is still an apolitical question. And the question largely pertains to the mandate of the National Commission for Scheduled Castes more than anything else. And that is why it becomes more important than anything else. Now, let's remember this as we move ahead. So, if you recollect a little bit of current affairs, you would recollect that the Supreme Court has finished hearing arguments about the case concerning Aligarh Muslim University as to whether Aligarh Muslim University is a minority institution under Article 30 and what are the parameters that should be made to determine whether an institution is a minority institution. Now, this case is originally titled as Faizan Mustafa versus Union of India. Faizan Mustafa, as you would know, is a very, very popular writer and a very popular legal personality. He happened to be the ex-vice chancellor of the Nalsar University of Law in Hyderabad. Of course, runs a legal podcast series and is very, very popular amongst the youth of this country. And he's also currently serving in an administrative capacity at the Aligarh Muslim University. So the case is filed on his behalf. But it is a Supreme Court case. The Supreme Court case is pending. The judgment has not been delivered yet, which means you can be asked an apolitical question on religious minority institutions or minority educational institutions or linking National Commission of Minorities to minority educational institutions and the larger scope of Article 30 if need be, therefore making it a green flag. Because in the news, judgment is pending, there is a prior occurrence of a similar question. Would you be asked a question on Aligarh Muslim? No. You would be asked a question on minority institutions or religious minority institutions or religious minority educational institutions. Either of them make perfect sense. This is why, ladies and gentlemen, it is very important for us to get our PYQs right, because through this, we're able to identify certain key topics. So, as a result of this, what are my factors that I'm considering? I'm considering anniversaries of judgments. I'm considering anniversaries of important constitutional amendments. Articles 19 and 21 are my showstoppers. Important Supreme Court cases in progress. Important human rights issues in US, UK, and France. And of course, there is election year context. This cross-referenced with dimensions and frequency of PYQs leads me to these outcomes. So, from core fundamental rights, I need to get minority rights, I need to get property rights, because postal bill, telecom bill, a bunch of these were in the news. Just for safety purposes, digital rights, because Uniform Civil Code was in the news, UCC, because the Supreme Court has delivered a bunch of judgments last year and this year in and around the aspects of right to life. So a larger discussion on right to life, specifically, just to be on the safer side, though not very important, still should be done. Article 14 fundamentally has to be done because Article 14 has been asked in the last 5 years, and a theoretical understanding of Article 14 just as the one pager to keep our ourselves safe. And then because it's election year, press freedom therefore becomes important. So because of these reasons, these are our shortlists from fundamental rights. Now, directive principles. When we look at directive principles, let's understand why and how is this important. See, I have mentioned property rights here, which is a culmination of the relationship between directive principles and state policy because of something called 39B and C. It's conflict with Articles 14 and 19, previously also 31 included, and therefore the larger issue with right to property. Anyway, we'll link it to directive principles. In 2015, there was a question which said, discuss the possible factors that inhibit India from enacting for its citizens a uniform civil code as provided for in directive principles of state policy. Now, this question was asked in 2015, celebrating exactly 30 years to the Shah Banu case. So there's an anniversary question. And if it's an anniversary question, the question will always be very reflective in nature. And again, if you see, they've not asked you your opinion on Uniform Civil Code, because your opinion on Uniform Civil Code might give away your religious affiliations. What they've asked you is, what is stopping us from implementing Uniform Civil Code as it is categorically mentioned under Article 44 of Directive Principles? So your answer, while the issue being extremely controversial, being sensitive, is still an academic and a very neutral answer. And that is something we have to keep in mind under all circumstances. Now, in 2024, we've seen Uttarakhand with Uniform Civil Code. We've seen several other states contemplating certain drafts. We've seen committees that have been formed to examine all of this. So therefore, this is an issue. Not just this, we've also seen very recently people of the same gender have been denied the right to marry. And the Supreme Court, in a remarkably important judgment this year, has used its extraordinary powers and has granted divorce to a couple because of certain extenuating circumstances. So we shall keep that in mind, and all of this eventually comes down to Uniform Civil Code, because marriage is a very important personal law governed across our personal laws. In 2023, the question was rather unique. Who are entitled to receive legal aid, free legal aid? Assess the role of the National Legal Services Authority in rendering free legal aid in India. And there's a context to this. This is a factual question as it sounds to be. Exactly who is entitled to receive free legal aid? And the agency responsible for this, the National Legal Services Authority, NALSA, what exactly have they done? And we're anyways around the 10-year mark in 2024 for the NALSA judgment, which effectively gave transgenders the official status as the third gender. But in 2023, the question was for a very different reason. The question was because in April 2023, if I'm correct with the month, India organized its first ever National Lok Adalat. And it is 35 years to the Legal Services Authorities Act, which is the parent statute allowing for the National Legal Services Authority to even exist in the first place as a statutory organization. And at this first ever National Lok Adalat held in Delhi, I believe close to about 70-80 lakh odd cases were disposed of in the duration of the first National Lok Adalat. So specific actionable elements therefore become extremely important. Now, what else in directive principles is an actionable element? You would say equal pay for equal work, but not much has been done on that front. Right to education, yes. But right to education from an education point of view is more of a social justice question, where you would be asked a review of the school education or the other education sectors, given the fact that higher education has been in the news, particularly in 2024, for foreign university campuses to have been opened up, to the National Testing Agency being in the news for the wrong reasons, therefore a larger issue of regulation of higher education, and so on and so forth. So therefore what eventually ends up happening is, we are effectively dealing with in directive principles a larger question which is in contemporary Supreme Court context. So if I look at my factors, I'm looking at anniversaries of judgments, anniversaries of amendments, anniversaries of landmark policy decisions, and important Supreme Court cases in progress. And my outcome is the relationship between fundamental rights and directive principles, ultimately leading to the doctrine of harmonious construction. Minerva Mills is the case, which is 1980, or approximately on the 25-year mark. Property has been one of the primary reasons behind Minerva Mills, because it was effectively about establishing a sense of a balance. In fact, it is in Minerva Mills where it was categorically established that the balance between rights and directive principles is itself an element of basic structure. In fact, it is in Minerva Mills which effectively laid down that limitations on Article 368 are also an element of basic structure, which we will cover in this lecture today anyway. So Minerva Mills becomes important. Property rights, because they're currently being discussed by the Supreme Court. The Supreme Court is basically hearing a matter, and the arguments have been done pertaining to whether the government can acquire private property under Article 39B and C and then redistribute it. The context behind this is that because of Minerva Mills, two directive principles are superior to two fundamental rights if there is no other objection. The two directive principles are 39B and C. The two fundamental rights are 14 and 19. Now 39B and C pertain to distribution of resources and prevention of concentration of wealth. And land happens to be one of the most vital resources. So if the government can acquire land, can it acquire private land? Now there has been a minority view in a state of Karnataka Supreme Court judgment where Justice Krishna Iyer had said that you can. But in a lot of other Supreme Court cases such as Coking Coal and Mafatlal, the Supreme Court has held the opposite, which is why clarity has been sought. And the case is in the news, it is because it has been pulled up by the Supreme Court, and this case is basically the Maharashtra House Owners Association who's filed this case. That's largely because of certain changes that were made by the Maharashtra government to their laws, which allowed for the government to take over old dilapidated buildings, which would basically deprive people of their right to property. That's the context to this. So right to property, relationship between basic structure, fundamental rights, DPSP, Minerva Mills, all of this is in the same universe and therefore is important for Mains 2024 and has to be done in a certain length and breadth of things. When we do right to property, it has to be a very basic question. what is the status of right to property, how did it evolve, and what is the Supreme Court doing about it. That is more than enough. But for Minerva Mills, for the relationship between directive principles and fundamental rights, there is a deeper discussion in place, which we will get into. Now, the grand of it all, basic structure. If it was not asked in 2023 when they had officially finished 50 years, you have to ask basic structure in 2024. If you look at the question carefully, the questions will sound complex, but they're actually not. In 2023, the question was, the Supreme Court of India keeps a check on the arbitrary power of the Parliament in amending the Constitution. Discuss critically. This is asked because of 40 years to the Kesavananda Bharati case, which is 1973. So 2013 becomes your anniversary year. And they ask you a larger reflective question. How does the Supreme Court keep a check on the amending powers of the Constitution? By limiting the amending powers. How does the Supreme Court limit the amending powers? By coming up with something called the doctrine of basic structure. Is this effectively good or not? So, this question basically had two parts. How does the Supreme Court do it? And what are the pros and cons of it? That's pretty much it. The thing with basic structure is, you have to study basic structure in a lot of depth and a lot of detail as far as rights is concerned. And when we do separation of powers or judiciary, when you do judiciary, judicial review and activism, which get completely more strengthened and fortified because of the doctrine of basic structure, have to also be done in a certain amount of detail. That's why it becomes all the more important in that context. Now, 2016. What was held in the Coelho case? In this context, can you say that judicial review is of key importance amongst the basic features of the Constitution? Now, I understand that the IR Coelho case happens to be 2007. This is 2016. The judgment was effectively reported in the month of January, 11th January 2007, if I remember. So the whole 10-year mark is very close to the 10-year mark, which is why it's allowed. So what was held in the IR Coelho case, which is basically that changes to the 9th schedule pre-1973 would also be judicially reviewable if they are questionable on grounds of basic structure, and therefore you link the basic structure doctrine to judicial review, which in itself is a separation of powers issue. It's a judicial issue. In 2019, again, so if you look at 2016's question, it's again about the impact of the basic structure doctrine. The point I'm trying to make here is, as much as we'll study the evolution of the basic structure doctrine to understand it, more than the evolution, what is more important is the impact of it, the situational justification of it, the necessity of it, and so on and so forth. In 2019, if you look at it, the question is just one step ahead of the 2013 question. The question says, the Parliament's power to amend the Constitution is a limited power, and it cannot be enlarged into an absolute power. In light of this statement, explain whether the Parliament under Article 368 can destroy the basic structure of the Constitution by expanding its amending power. Basically, the question is, the Parliament's power is limited to amend the Constitution, which is very similar to 2013. And it cannot be an absolute power is an extension of the 2013 question. It cannot be an absolute power because it will go against the spirit of constitutionalism. It will go against the spirit of rule of law. It will go against the spirit of what is truly called a majoritarian democracy and not just a representative majoritarian democracy. But the trick to the question was the second half of it. Can the Parliament itself destroy basic structure? And I've attempted to answer that question in this lecture as well. The reason this was asked in 2019 is because when petitions were heard with respect to abrogation of Article 370 and challenges to the CA of 2019, the primary grounds that were actually alleged was that CA goes against the spirit of secularism, and secularism is basic structure. Abrogating 370 takes away the nature of asymmetric federalism, which is an extension of federalism, and federalism is basic structure. Of course, with Article 370, the Supreme Court has delivered the verdict. With CA 2019, the case is called the Indian Union Muslim League versus Union of India. The case still is sub judice, which means I have to do a very, very thorough impact analysis. And then the important part is I have to put it all together. So combining all of these four things, these become my primary focus areas. Basic structure and harmonious construction. This includes the relationship between fundamental rights and directive principles and Minerva Mills and property rights. Lecture 2.1 covers all of this because they're in the same universe, and I'll show you how they're in the same universe. It's the same timeline, which therefore has multiple branches or tributaries, if you'd like to call it that, which effectively lead to the same judicial outcomes. We've got to do minority rights, UCC, 19 issues, 21 issues, 19 and 21 common issues such as digitization and privacy, Article 14 scope and doctrines, and I didn't write it here, a preamble, DPSP and fundamental duty utility analysis, just to be on the safer side. If there has to be a question, it has to be from these 9 topics, otherwise we're in deep trouble. So this is exactly how we're going to go about it, and we're going to start with what is called the first 2 topics, which is effectively going to take a lot of time because they're very extensive topics. We're going to be dealing with the doctrine of basic structure, which is correlated to the doctrine of harmonious construction, which also leads to a larger understanding of right to property, which will have, all of this will have an impact on the relationship between fundamental rights and directive principles, on judicial review, and so on and so forth. So it is all interrelated. We will do this in a certain manner, and we'll start right about now. So that's the idea. This is the process. Now we start with the first topic, and I'll introduce the topic. I'll give you a timeline and tell you how this has to be done in a certain way. So in an integrated and a combined manner, we will be studying the basic structure doctrine, harmonious construction, which effectively means understanding amenability of fundamental rights, relationship between directive principles and duties, directive principles between rights and directive principles, and property rights, because they're all interlinked. So what I've done this time for Mains Magna Carta 2024 is that instead of giving you open-ended notes, I've put them in a question-answer format, which you can memorize verbatim, and the questions will fall into place, and write the answers as they are. There are a total of 15 questions that can come from these 3 topics. They are, first, what is basic structure? What is the rationale behind it? What is the relationship between basic structure and constitutionalism? What is the relationship between basic structure and rule of law? How did the basic structure evolve, which is a low priority question? What was specifically held in the Keswanand Bharti case? What has been included in the basic structure? Very importantly, what is categorically excluded from the basic structure? What is the impact of basic structure on fundamentally 3 aspects, which is judicial review, activism, and parliamentary sovereignty, among, of course, other things? What is the critical analysis, or what are the criticisms leveled against the doctrine of basic structure? A question that has been asked before, and therefore we should keep it as a safety net. Can basic structure be amended or diluted? Just a little bit of comparative constitution to just make answers reach that level or get that kind of value addition. How do other countries deal with it? Extension of it, what is held in the Minerva Mills case? Why is this case important? And what does it lead to the relationship between rights and directive principles, and effectively what is the nature and state of property rights in India. Now, the idea is the story effectively starts from rule of law, and rule of law has three basic principles: equality before law, you have absence of arbitrary power, and predominance of legal spirit. All of these three effectively try to create some form of limitations on the powers of the state, which leads to a larger theory called the theory of implied limitation, wherein, if not directly, are there any indirect ways in which you can restrict the powers of the parliament to amend the constitution? This becomes the basis of something called constitutionalism, which effectively translates into the constitution, which has to be protected by the doctrine of basic structure, which ultimately leads to the doctrine of harmonious construction. One of its meanings is the relationship between fundamental rights and directive principles, and the journey is traversed through an evolution of property rights. So the basic idea is to walk us through this journey, is to understand the yes and the no and the pros and the cons of it. And that's basically the premise. Now, having said that, it is through this that we will be able to understand the length and breadth of it. Now, what I've done is, I've created what is called a consolidated timeline. This timeline contains all the three elements that we are dealing with: amenability of fundamental rights, ultimately leading to the doctrine of basic structure; relationship between rights and directive principles, ultimately leading to the doctrine of harmonious construction. And while we evolve on this, we will also see our journey on property rights. And this becomes the consolidated timeline. So if we get a question on either of this, you can use portions of this timeline to answer our questions as accurately as we can. The idea is, the story starts with the element of socialism, which translates into having certain land reform measures which become objectionable on certain fundamental rights, wherein there is a curtailment of these fundamental rights, which leads to a larger discussion on whether the constitution can be changed. And this therefore leads to the creation of the doctrine of basic structure. These land reforms are also executed in the name of directive principles, ultimately leading to the relationship between rights and directive principles, which effectively lead to the doctrine of harmonious construction. And land is closely related to property. So the evolution of property rights also becomes extremely integral to the process. In a very simple manner, this is the flow of events. And this flow of events is depicted across this timeline. Let me just walk you through it and then we'll discuss the rest of it all. The story starts with the idea of equal distribution of resources. When India became independent in 1947, we inherited a rather poor state of affairs. Our literacy rates were averaging out to be about 16%. The female literacy rate was below 16%. We had a substantial chunk of our population, and even till today, engaged directly or indirectly in the agrarian sector. And very few people owned very large chunks of land in a country which was dominantly agrarian. And if you wanted to evolve and develop your country, you would have to effectively undertake agrarian reform in the nature of land reform. If more and more people had access to more and more ownership of land, not only would agricultural productivity increase, you would also have a legitimate increase in the amount of money that people are able to make. In this spirit, deeply influenced by Russian models of socialism, we embarked on a journey of land reform measures. And land, as we understand, is a finite commodity, which means you cannot generate land. What you can do is redistribute it. Now, redistribution would mean people who have excess amount of land, their land has to be taken or purchased by the government and redistributed it amongst the people who don't have land. This means you will have to put a ceiling on the amount of land that one could own. And therefore, what would effectively happen is that you would ask your state governments, because land is a state subject, to undertake land reform laws. And these land reform laws will therefore ensure that in each of these states, people cannot hold more than an X amount of land. If they do, that land would be compulsorily purchased at a fair price, hopefully, by the state. Now, for this to happen, we were lucky enough to have similar political parties and majority at the center in the states. Therefore, several states were able to pass these land reform acts. That's the basic idea. Now, let us look at the legal provisions in play. These land reform acts created limits on ownership of property. Now, there are two aspects of this. One, right to property was a fundamental right back in the day. It was a fundamental right reflected across two provisions, 19(1) Clause F and Article 31. The other aspect to this is, because these fundamental rights stood to be violated, as you would limit the amount of property an individual would effectively own, it would eventually lead to people challenging these land reform acts in the courts of law. You would challenge them under 32 and 226 at the Supreme Court and the High Courts respectively. Most of them were initially challenged at the High Courts. Using a provision called Article 13 Clause 2, which basically said no law can violate fundamental rights. Now, the meaning of the word law would be disputed and greatly debated. But this is largely the starting point of it. What happens post this are changes to property rights, are changes benefiting the government on acquisition of property, and so on and so forth. So when this started out, several zamindars across state governments, across states, started challenging these state land reform acts at their respective state high courts. Now, the judgments that were given by the respective state high courts were very varied in their own right. A few state high courts upheld these land reform acts, and a few state high courts struck these land reform acts down. The parliament, of course, had a majority at that time, so the central leadership decided to take a call and said, you know what, let's try to solve this. And therefore, they decided to insert, via the first constitutional amendment of 1951, two provisions ahead of Article 31, which was 31A and 31B. 31 was your basic right to property. So 31A and 31B. So what basically happened was, through the first constitutional amendment of 1951, Articles 31A and Articles 31B were added. Article 31A basically set the record straight. It basically said, if the government is acquiring your fundamental right, if the government is acquiring your property, then no fundamental right is violated. If the government is acquiring your property, if there's a governmental land acquisition, then no fundamental rights are violated by governmental land acquisition. Just to set the record straight. And Article 31B basically added the 9th schedule to the constitution, and the central government, the parliament, via constitutional amendment, because only the parliament can amend the constitution, the states cannot directly put anything in the 9th schedule. The parliament inserted some of these state land reform acts to the 9th schedule. Fair enough. The magic behind 9th schedule was, whatever is inside 9th schedule could not be judicially reviewed. As simple as that. That's effectively what happened through the first constitutional amendment of 1951. Now, what does this mean? It means zamindars or landowners cannot challenge the land reform acts because they have been placed in the 9th schedule of the constitution, thereby making them immune from judicial review. That's effectively what it means. So now they are in a fix. One such person was Shankari Prasad. So Shankari Prasad Singh Deo in 1951 challenged the 9th schedule itself. We understand that you can't challenge what's inside the 9th schedule, but you can challenge the 9th schedule nonetheless. So what Shankari Prasad Singh did was, Shankari Prasad Singh challenged the 9th schedule in toto. And therefore the arguments were between the lawyers of Shankari Prasad and of course the law officers of the central government, the Attorney General. Now the argument was a very simple one. Shankari Prasad's lawyer went up to the Supreme Court and said, and this by the way was a simple 3:2 bench. The judgment was 3:2, we'll come to that later. So basically what Shankari Prasad's lawyer said in the Supreme Court was, my lords, these land reform acts violate my right to property. Article 13(2) says, no law can violate my fundamental right. These land reform acts are violating my fundamental rights. I am unable to challenge these land reform acts because they're in the 9th schedule. So the 9th schedule contains something which violates my fundamental rights. And my inability to challenge something in the 9th schedule also violates my fundamental right of right to constitutional remedies under Article 32. Let us not forget that Article 32 itself is a fundamental right. Though it's technically a power of the Supreme Court, it's the jurisdiction of the Supreme Court. But the makers of our constitution were visionary enough to put Article 32 in Part 3 and not under Supreme Court provisions of the Constitution. So Shankari Prasad's lawyer in the Supreme Court was categorically simple about this. No law can violate a fundamental right. Land reform acts are violating my fundamental rights to property. And therefore, ninth schedule is violating my fundamental right to property. And me unable to challenge the ninth schedule is violating my right to not enforce my fundamental right. So not only is my 31 getting violated, my 19 clause 1F is also getting violated. And why am I as the landowner getting singled out? If I as a landowner am getting singled out, which means that you're treating me differently than everybody else. So therefore, my 14, 19 and 31 stand to be violated. This kind of a connection is built up from Shankari Prasad's case. Now the Attorney General of India vehemently stood up before the Supreme Court and said, my lords, Article 13 clause 2 says, no law can violate a fundamental right. The word law in Article 13 clause 2 refers to ordinary legislative powers of the Parliament. The powers that the Parliament has under the 7th schedule, which is read with Articles 245 and 246. The word law here does not refer to the power of the Parliament to amend the Constitution. Because the power of the Parliament to amend the Constitution is not under Schedule 7. It is dedicatedly mentioned under Article 368. So, my lords, the Parliament effectively has two powers. A legislative power and a constituent power. The legislative power of the Parliament is to make ordinary laws. Laws under 7th schedule, in the union list and the concurrent list, and under rare scenarios on the state list. But the constituent power of the Parliament is a power much beyond legislative powers. It is protected under Article 368. And the Parliament is the recipient of that power because this power has been transferred to the Parliament from the Constituent Assembly who received this power through the Indian Independence Act of 1947, which was an outcome of the Cabinet Mission Plan. So while Shankari Prasad's lawyer is absolutely right that no law can violate a fundamental right, this is not a law. Ninth schedule has been inserted through a constitutional amendment, my lord. And therefore constitutional amendments are not law. Now the Supreme Court had about 5 judges who had sat on this because the bare minimum number of judges you require for a constitution's bench is 5. So therefore, in a very narrow margin of 3:2, and you will see this across the board, it will always be a wafer-thin majority. The Supreme Court said exactly this. The Supreme Court agreed with the Attorney General of India and said, you are absolutely right. Constitutional amendments are not law as per Article 13 clause 2. And it is the Parliament who effectively has the power to amend the Constitution. They are the custodians of it. And therefore, the Parliament can amend anything in the Constitution they feel like. So Shankari Prasad lost. Ninth schedule was given its due protection, and the land reform laws stood to be valid. Nothing succeeds like success, ladies and gentlemen. Through the 17th Constitutional Amendment of 1964, the government only grew with confidence, knowing that a constitution bench of the Supreme Court has given a judgment in the favor of the government. So through the 17th Constitutional Amendment of 1964, the government added more laws to the 9th schedule. More laws which were passed by the state legislatures, adding them to the 9th schedule, therefore giving them more protection from judicial review. And 2 such laws that were added which is the cause for the next two cases, were one, Rajasthan, and second, Punjab. One, Rajasthan, and second, Punjab. Now, Sajjan Singh, another landowner, challenged the same. Challenged the ninth schedule because the Rajasthan state laws were added to the ninth schedule. Now, Sajjan Singh's lawyer had a slightly different argument, slightly different from Shankari Prasad's lawyer. Sajjan Singh's lawyer questioned the procedure through which the ninth schedule was inserted in the constitution. Because land pertains to the state subject and ninth schedule is giving protection to land laws, this kind of a constitutional amendment, according to Sajjan Singh, should have required state ratification. The Attorney General of India obviously disagreed before the court. And in Sajjan Singh's case, very simply put, in Sajjan Singh's case, the court again gave the favor to the government. Simply gave the favor to the government. Now, in an extremely narrow 4:3 judgment, the judges gave exactly the same verdict as Shankari Singh. When I show you the answer, you will write both of these judgments together. And that's what happened. Now, Golaknath became a turning point. Golaknath was a very, very wealthy landowner in Punjab who had hundreds of acres of land, which were obviously in excess, were compulsorily purchased by the government of Punjab. And the law that allowed the government of Punjab to do this was protected under the ninth schedule. As an outcome of this, Golaknath also challenged the ninth schedule in the Supreme Court. Now, in the Golaknath case, very interestingly, a 11-judge bench sat, and the judgment was again a wafer-thin majority of 6:5. Golaknath becomes a very interesting case because of the turn of events that it had implicated. Golaknath's lawyer came up and said the same thing, but in a very rigorously different fashion. It said that the Attorney General is claiming that the Parliament has the power to amend the Constitution, and the Parliament has been given that power by the Constituent Assembly. My lords, where in the Constitution is this written? If you actually read the text of the Constitution at the time of Golaknath, Article 368 did not read power of the Parliament. My lord, it read procedure of the Parliament. It merely enumerated the procedure through which the Parliament could amend the Constitution. It never spoke of any powers. And in fact, the Parliament got these powers under residuary powers, because whatever is not listed anywhere is a residuary power under the 7th schedule. The Attorney General begged to differ. That the power of the Parliament to amend the greatest law of the land, the sovereign law of the land, and the power of the Parliament to enact the legislation cannot be the same power, simply because of the impact that it has. Because the Constitution and any other ordinary law are not the same laws. All other laws have to abide by the Constitution and not the other way around. It is in this case that the seeds of basic structure were sown, rootified and cemented in case 1, and then we'll discuss this. It is to this that the Golaknath's Golaknath's lawyer said, if that is the case, then there is absolutely no limitation on the Parliament to make any changes to the Constitution. And if the parliament can make any changes to the constitution, then why do we even have a written constitution? We have a written constitution so that the agencies of the state are subordinate to the written constitution, so that they can abide by it. It is the written constitution that gives you structure, powers and functions to the agencies of the state and not the other way around. So what you're effectively trying to do is basically give unlimited draconian powers to the parliament, if I may add, my lord. That's effectively what happened. In an unseen turn of events, the Supreme Court categorically agreed with Golaknath. And the Supreme Court said, you're absolutely right. In fact, the Supreme Court was a little too on the side of Golaknath. The Supreme Court said, you're absolutely right. And the Supreme Court overturned Shankari Prasad and Sajjan Singh in Golaknath and said very categorically that there is no difference between constituent power and legislative power. They're effectively the same. And constitutional amendments are absolutely law under Article 13 Clause 2, which means they cannot violate fundamental rights. Which means the parliament does not have the power to amend fundamental rights. This goes against the premise of the other two cases. Because if the parliament cannot amend fundamental rights effectively become frozen in time. They're fossilized. Which may not also be good for the organic evolutionary growth of the constitution. But such is such. And this was the judgment of Golaknath. There is no difference between ordinary power and constituent power. Constitutional amendments are law as per Article 13(2). And 368 does not give you the power but merely enumerates the procedure for the parliament to amend the constitution. So be it. Because of this, the government obviously had a setback. And in law, as in most other things, the year and the political context matters. 1967 are pre-emergency years. An era where you see the growth of strong regional forces, regional parties. Political defections in our country are going to be at an all-time high in 1969. So the central political leadership belonging to a particular party is going to obviously feel threatened. And such is the case. I'd like to take a pause here and bring you up to speed on this aspect as well. Because it culminates to Golaknath. Let's understand how. The conflict between fundamental rights and directive principles is in fact a utilitarian conflict. It's a conflict on who do you intend to protect. Do you intend to protect the individual, or do you intend to serve the society as a whole? Because sometimes, if you are serving society as a whole, the rights of the individual may stand to be compromised. And that is something you may or may not be okay with. So this conflict between rights and directive principles will eventually amalgamate into this story, and we'll see how. The story starts in 1951 with India's first ever reservation case called Champakam Dorairajan versus State of Madhya Pradesh. It is in this particular case, and it is India's first ever reservation case, it is because of this case that Articles 15 Clause 4 was added to the Constitution of India immediately after this case. Champakam Dorairajan versus State of Madras is a case because at that time, pre-organization in 1956, it was called the State of Madras. And the State of Madras had come up with a reservation policy. And at that time, the constitution did not specifically provide for reservation on the basis of certain castes. The Supreme Court effectively struck it down. While the Supreme Court was hearing this matter, the lawyers from Champakam said there is nothing in fundamental rights, or there is nothing in the constitution that allows the government to reserve on the basis of caste. How could the state of Madras do this? The government's response was, we are doing this to implement directive principles which call for a better standard of life, which call for a better quality of life, which call for effective distribution of resources and prevention of concentration of wealth. And wealth will stand to be concentrated only if people who are societally forward get to access opportunities available to those who are societally forward. So that is how it also became a conflict between fundamental rights and directive principles, rightfully so. As an outcome of this, the Supreme Court struck down the reservation policy and also said that fundamental rights will effectively be supreme. It is post this, the Supreme Court reiterated it in reference Kerala Higher Education Bill of 1957, where a bill which was again on reservation, passed by the Kerala Legislative Assembly, sent to the governor for his assent, was forwarded to the president because of the constitutional discretion due to the governor under Article 200. And the president exercised his constitutional powers seeking a Supreme Court reference. And that's how it became in reference the Kerala Higher Education Bill of 1957. However, in this case, the Supreme Court, the arguments are more or less the same. The discussions are more or less the same. But the Supreme Court said ultimately, you must try and maintain a balance between fundamental rights and directive principles as much as possible. And the idea of having a balance between fundamental rights and directive principles effectively means the birth of something called the doctrine of harmonious construction, which gets solidified later in the Minerva Mills case. And if at all there is a conflict, let's try to avoid one as much as possible. But if at all there is a conflict, that conflict would be in favor of fundamental rights over directive principles. So in both Champakkam and Kerala Higher Education, fundamental rights were to be given precedence over directive principles after all attempts have been made in vain to harmonize relations between them. And that's effectively the idea, rightfully so. And in Golaknath, when the Supreme Court categorically said the Parliament can't touch fundamental rights, they are sacrosanct, in a way that fundamental rights would also be more important than anything else, including directive principles, Golaknath was also a setback on the harmonization efforts between fundamental rights and directive principles. In response to the Golaknath judgment, which now is the culminating judgment for both amenability of fundamental rights and the relationship between fundamental rights and directive principles, in the same year in 1971, a triage of constitutional amendments were passed by the government of the day through the Parliament. And each of these amendments have a very significant value in their own right. Through the 24th Amendment, the 24th Amendment directly overrules Golaknath. Now, this is a point of concept. When the Supreme Court delivers a judgment, the Parliament can pass an amendment nullifying that judgment. Because in a parliamentary democracy, through democratic mandate, it is the elected House of Representatives that would effectively have the powers over and above an unelected bunch of judges. So basically, through the 24th Amendment of 1971, You added a clause in Article 13 called 13 Clause 4 and a proportionate clause under Article 368. But the 13 Clause 4 article very categorically said that constitutional amendments are not law as far as 13.2 is concerned, directly overruling whatever was said in Golaknath. Through the 25th Amendment of 1971, this was an amendment primarily targeted on the relationship between rights and directive principles, whereas the 24th Amendment was about amenability of fundamental rights. 25th was about the relationship between rights and directive principles. Through the 25th Amendment of 1971, Article 31C was added. We've already had 31A and 31B. And what Article 31C effectively says is, two directive principles, 39B and 39C, are superior to 14, 19 and 31. Which basically means, if the government attempts to implement directive principles under Articles 39B and C, which is effectively equal distribution of resources and prevention of concentration of wealth, and your only objections to these two implementations is equality, property under 19 and property under 31, then your individual rights are lesser significant than the collective implementation under 39B and C. 39B and C is not just about property, it also is in response to the Supreme Court invalidating certain nationalization laws made by the government. More specifically, when the government attempted to nationalize banks. And in the Rustomji Cooper case, the Supreme Court struck down that nationalization policy. So when I use the words prevention of concentration of wealth and equal distribution of resources, please bear in mind, though land is the most obvious outcome of this, it's not the only outcome. So there was a context to this. The government's justification in nationalizing resources, such as banks, was also Article 39B and C. So the 25th Amendment has a very unique role to play, because it places two directive principles over three fundamental rights, part of which still holds to be true. The problem is not just with this. The problem is, whenever something like this will happen, such an activity shall not be judicially reviewable. Such an activity shall not be judicially reviewable, which becomes a red flag. And through the 29th Amendment, several state laws were added to the ninth schedule, one of them being land reform laws of Kerala, which therefore leads to the grand case of Keswanand Bharti versus State of Kerala in 1973. Now, uniquely, Keswanand Bharti was the head of the Edgar Mutt in Kerala. And we are absolutely certain of the fact that minorities are people who are in a lesser numerical population in that state. This is as per Supreme Court definitions of what is a minority. So therefore in Kerala, Hindus were a minority. And Hindus holding land in Kerala was land held by a religious minority. Therefore, it was not just about 39B, 39C, 14, 19, 31, etc., etc. It was also about the larger provisions of Articles 29 and 30. because it is under Articles 29 and 30, more specifically Article 30, that linguistic and religious minorities have the right to establish their institutions. And not only 29 and 30, religious denominations under Article 26 also have certain rights to acquire movable and immovable property. So the aspect of the case became a little brighter and a little wider. Now, Golaknath was 11-judge bench, which means the Supreme Court had to set up a 13-judge bench in Kesavanand Bharti. And it had to deal with all the issues up until now. So, just to put it out there in a summarized form, Kesavanand Bharti is not a pro-judiciary judgment. Kesavanand Bharti is actually a judgment which tries to sort of create a balancing act. It tries to balance the powers and the aspirations of all the agencies of government. And therefore, let's understand how that happens. In the Kesavanand Bharti case, the Supreme Court said the Parliament can amend anything in the Constitution they want to, no problem at all. They also said that we are overruling Golaknath to the extent that constitutional amendments are not to be law for 13(2) purposes. That means we're upholding the 24th Constitutional Amendment. And while the Parliament has, and this is where they flip, while the Parliament has the powers to amend anything in the Constitution, that anything must come with a certain amount of implied restrictions. Otherwise, the concept of the Constitution will stand to be questioned in the first place. So therefore, what is it that the Parliament cannot amend in the Constitution will be a bunch of principles and not provisions. And these principles would be enumerated by us, not only in this judgment, but by our fellow judges in the judgments to come over a longer period of time. And as long as these principles are not violated, the Parliament can amend anything in the Constitution. For example, if secularism is basic structure, technically the Parliament can amend Article 25, but in a way that it does not adversely affect secularism, is what the judges meant in Kesavanand Bharti. On top of it, from Golaknath onwards, they've been following a doctrine called the doctrine of prospective overruling. This means judgments should always be from today or from a day forward. It cannot be from a day backward. So even when Golaknath won the case, Golaknath didn't actually get the land back. The same applies to Kesavanand Bharti as well. And therefore, in Kesavanand Bharti also, the Supreme Court applied the doctrine of prospective overruling, and in fact said that it will be applicable from today onwards, which means whatever additions have been made to the 9th schedule up until the date of judgment, which I think is the 24th of April 1973, whatever laws have been added to the 9th schedule up until the 24th of April 1973 shall continue to be as it is, as they are. No matter how objectionable those laws might be, those laws shall not be touched under any circumstances whatsoever. They will continue to be immune from judicial review, while having said that judicial review is basic structure. While judicial review is basic structure, we will not judicially review whatever was added to the 9th schedule before the date of judgment, which is the 24th of April 1973, as categorical as they could sound. So the Kesavanand Bharti judgment, as we will descriptively understand, is primarily a judgment which tries to perform what is called a balancing act. It is not a one-sided judgment contrary to popular belief. It is a judgment which tries to balance the aspirations of both the agencies of the state, as we've tried to understand before. The Kesavanand Bharati judgment effectively will lead to certain repercussions as well. And one of the most important ones is that immediately after this judgment, an attempt will be made to overturn this judgment, but very interestingly and very surprisingly, the bench of that entire judgment, of that entire setup, was dissolved under mysterious circumstances because the emergency was in place. And that's why there is no official record of the same. Because the press was censored to report on court judgments, as it is. Nonetheless, in 1975, we were in a state of emergency. And in 1976, via the 42nd Constitutional Amendment, the government undertook some rather, for the lack of a better word, dramatic changes to the Constitution. Through the 42nd Amendment of 1976, the government primarily attacked the relationship between fundamental rights and directive principles. And not only this, it also attempted to reverse the Kesavanand Bharati judgment by adding provisions to Article 368, saying basically the basic structure doctrine will not apply and the parliament can amend whatever it wants to. Now, how does the government basically expand the relationship between rights and directive principles? What the government does to the 42nd Amendment is, it says instead of just 2 directive principles, all directive principles of state policy are greater than 14, 19 and 31. And they will still continue to be beyond the ambit of judicial review, despite the fact that Kesavanand Bharati has categorically said judicial review is basic structure. And they make changes to Article 368, dominantly allowing for certain special powers to be given. Basically trying to overrule what was held in the Kesavanand Bharati case. Through the 44th Amendment of 1978, immediately 2 years after, and a simple way to remember it is 4 plus 2 is 6, so 1976, and 4 plus 4 is 8, so 1978. Through the 44th Amendment of 1978, the Supreme Court struck at the root cause of this problem. Whether it is amenability of fundamental rights which started with land, or whether it is about the relationship between fundamental rights and directive principles, which ultimately amounted to also land, let me cut property out of the equation. And through the 44th Amendment of 1978, right to property was effectively deleted as a fundamental right. There were certain changes that were made to Article 31. And right to property, instead of a fundamental right, became a constitutional and a legal right. This was also a prelims question back in the day. And through the 44th Amendment, the government kept all directive principles superior to 14 and 19, and of course 31 would no longer be applicable. But they said it would still be judicially reviewable. In a way, softening the blow. And because all directive principles were now superior to 14 and 19, in this pretext, the government nationalized a textile mill from Karnataka called the Minerva Mills. In fact, the father of the great Nandan Nilekani used to work at the Minerva Mills. So the management of Minerva Mills challenged this in the Supreme Court. Now, of course, this Nationalization Act was also placed in the 9th schedule. So they had to challenge the 9th schedule under 32. The same logic as Sajjan Singh and Shankari Prasad and so on and so forth. And in Minerva Mills, you basically moved back in time and reaffirmed what Keswanand Bharati said. Basically saying there should be a harmonious relationship between directive principles and fundamental duties. And not all directive principles, but 39B and 39C tend to be more important than 14 and 19 if these are your only objections as they stand. And all of this would be judicially reviewable because judicial review is basic structure. And that is how you try to harmoniously construct the relationship between rights and fundamental duties. Rights and directive principles. One could possibly say that Minerva Mills was the last battle of the lot, in the sense that the last attempt that was made by the government was via the 42nd Amendment extendable to the 44th. And this was thwarted in the Minerva Mills case, and I've written this down in an answer form also for you. A few years later, in Vaman Rao case of 1981, the larger discussion happened about what about those laws which are in the 9th schedule before 1973. The Supreme Court did not give a very clear-cut answer. They should have, but they didn't. But in I.R. Coelho in 2007, the Supreme Court did. Very categorically said, everything is subject to judicial review if it violates the basic structure. Doesn't matter even if it's put in the 9th schedule before 1973, the 24th of April. That's largely what the case line is. Now, questions have already been asked from here. This is not significant enough, so we don't have to worry about it too much. But this is the story. Now, how does this story sort of come to property? Because from this onwards, the 25th Amendment has a role to play. Because 39B and C are greater than 14, 19 and 31, which means an individual's right to property is inferior to a directive principal action of the state. So land reforms over individual rights to property, which is why property rights become important. Supreme Court has majoritively held the government should not ordinarily acquire private property for these purposes. But after the Minerva Mills case, when right to property is no longer in the equation because it has been removed, and 39B and C tend to be stronger than 14 and 19, that means what is the impact of land reforms and right to property in government acquisition as an extension of 39B and C on equality and Article 19 per se. That's the larger discussion. So that is how right to property gets evolved, which we will eventually study. And if you actually look at it in a certain way, a lot of things either flow from here or flow into here. For example, in the presidential reference of the Berubari Union case of 1960, where Berubari Union was a part of the new Jalpaiguri district of West Bengal, and it was disputed in a form. But the idea was that in the Berubari Union case, the Supreme Court categorically said that if you are giving away undisputed land, then it would require a constitutional amendment under 368 by passing ordinary provisions protected by Article 4, where you do not require an amendment to territorial changes. Now, if you're giving away land to another country which is undisputed, you're doing that out of goodwill, and of course there is some amount of damage to the states. And land is an instrument of sovereignty, and sovereignty is mentioned in the preamble. So it is in the Berubari Union case where there was a larger discussion on the legal status of the preamble. And the Supreme Court said that the preamble is not an integral part of the Constitution. It is no source of power nor a source of limitation. This got extended up to Golaknath, and the preamble was also discussed because land reforms are about socialism, which is also in the preamble. And then in Keswanand Bharti, they also gave a little bit of insight on the preamble and said the preamble is an integral part, though a non-justiciable part. And it is neither a source of power nor a source of prohibition, though certainly is a key to the mind of makers of the Constitution, which is fair enough. In fact, from the Champakkam case, you will see Article 15 Clause 4 which is added, which then eventually leads to the evolution of reservation policy. Because of protests that were done with respect to how questionable the implementation of land reforms were, there is actually a judgment that comes around the time of 1962-1963, Kedarnath versus State of Bihar, which happens to be the Supreme Court jurisprudence on sedition. So you will see something to do with sedition also as an outcome of land reforms. Very interestingly so. So somewhere or the other, the basic structure doctrine has had an instrumental role to play in the legal evolution of this country, and these are just 2-3 examples. Almost every major legal doctrine somehow comes to this point. Now, once we've understood the length and breadth of it, at the end of the day, we're writing the mains exam. So it has to be written with a certain amount of precision, and it has to be written with a certain amount of acumen in place. Now that you've understood the length and breadth of it, you've understood the basic concepts behind it, let's get down to business. Question number 1. What is basic structure? This is your introduction. Now, if it's a 10 marker or a larger question, I've given you your points. These points also include value addition points. So there are some essential points and there are some value add points. Value add points are to be only written once you've written the essential points. Make no mistake, value addition is not a replacement for essentiality. You write all the fancy things in the world, but you ignore the basics, you're still going to get less marks. First, you must write what everybody writes, and then you must write that nobody writes. That is how you go beyond a 120 as far as this exam is concerned. So in one line, how do you explain basic structure doctrine in an introduction? Basic structure doctrine is a constitutional law doctrine that places restrictions on the amending of certain essential or basic principles embedded in the Constitution, and that's that. It is nothing but a doctrine that places restrictions on features of the state. Now the question is, how does this work? Why was this even a question mark? How does this start? Now this is an essential point and this is a value addition point. There was a professor in Germany called Professor Conrad. Between 1914 to 1918, some radical amendments were made to the German constitution, the Weimar constitution, the Weimar regime. This is when Hitler was in power. And these amendments that were made to the constitution of Germany effectively gave too much power to the government of Germany. And the German law professor Conrad was deeply disturbed by this idea. And therefore he came up with the idea of the theory of implied limitation. That even if not directly, if you have a written constitution, the purpose of it is to limit the powers of the agencies of the state. And the agencies should not have powers grand enough to change the constitution itself. And the German law professor Conrad, if I remember correctly, delivered a lecture at the Banaras Hindu University in 1965, which is where this idea was picked up and was quoted in Golaknath in 1967. That's the historical origin of this. And in fact, in the reservation case of M. Nagaraj, the court has actually reaffirmed that the basic structure doctrine owes its origin to the theory of implied limitation. So there is jurisprudential evidence for the same. The third point is again a value addition point, wherein you say, and we've discussed this, that the idea of basic structure was honestly discussed very briefly, very briefly in the Golaknath case. In fact, Justice Mudholkar, if I remember correctly, was one of the judges who had given some thought to this. But the doctrine came to its fruition and its totality in the Kesavanand Bharti case of 1973. The fourth point is also a value addition point, where you can bring in the greatest lawyer that has walked the lands of this country, Mr. Nani Palkiwala. One of the finest lawyers this country has ever seen, and perhaps the continent, if not the world. It is Mr. Nani Palkiwala who in Golaknath, in Kesavanand Bharti and Minerva Mills reaffirmed and persuaded the court towards the idea of the basic structure doctrine, which you've written categorically here. And the final point, which is also a value addition point, is, and this is a reference of a quote just for ornamentalization purposes, because nowadays we're in the era of ornamentalization. In a book written by Zia Modi, who happens to be one of the finest corporate lawyers in this country and also the finest legal minds of our country in our contemporary times, a book which is immensely popular amongst non-serious readers of the law who want to get a cursory understanding of the law. The book is exemplary because of how simply it's written and how effectively it's written. The book is called 10 Judgments That Changed India. And in that book, the first case that she begins with is Kesavanand Bharti, and therefore is hailed as a landmark in modern constitutional law jurisprudence. And this is your set introduction for a question on basic structure. Now, if it is a longer question, or the question specifically asks, what is the idea or what is the rationale behind the doctrine of basic structure, we've got a few points in mind. The idea of the doctrine of basic structure is primarily based on the theory of implied limitation, as we've discussed. The idea is, in a written constitution, the parliament cannot have powers to supersede the constitution. So the parliamentary powers to amend the constitution must be subject to certain restrictions as we would understand them to be. When you're able to do this, not only is the purpose of the written constitution met, the purpose of constitutionalism also seems to be intact. And by the way, all of this is in a A4 handout for you, so please keep that in reference when you're watching this lecture. And when you limit the powers of the parliament to amend the constitution, you make sure that the parliament does not have arbitrary powers to amend anything it wants in the constitution. And if they do, you can challenge that in a court of law, therefore fulfilling the essential ingredients of absence of arbitrary power and predominance of legal spirit as the two pillars of rule of law. And Justice Ashok Ganguly, who retired, wrote a very interesting quote. It's from his book that is called Landmark Judgments That Changed India. It balances the power of the parliament to amend the constitution and the Supreme Court's power of judicial review of those amendments. So it is in fact a harmonizing principle. It's not something that you would look at which tends to tilt things in the favor of the judiciary, though it sort of does, and we'll come to that and how. But that's not the primary ingredient. And my question number 2 is sorted. Question number 3 and 4 are again conceptual jurisprudential questions that can be asked, which is the relationship between constitutionalism and rule of law. A simple way to do this is, we've understood constitutionalism is based on the principle of limiting the powers of the state. And a constitution is nothing but a living form of constitutionalism. So a constitution, therefore, among other things, basically has to provide for the structure, functions and organs of the state. And when you're providing for structure, functions and powers of the state, powers will always have to be drawn through a line. You can do X, but you can't do Y. And one of such powers that the constitution has to provide for is the power of the parliament to amend the constitution. And if this power is unadulterated, and if this power has been given a free hand, if the parliament is given a free hand to amend anything in the constitution that the parliament would like to, it would effectively lead to the parliament amending such provisions of the constitution that are critical to the functioning of this democracy. And that is effectively my point. You require this to preserve constitutional principles, to preserve the ideals of democracy in a welfare state. And therefore, the doctrine of basic structure puts a leash on the parliament, and sorry for the harsh words, but the doctrine of basic structure sort of puts a limitation on the parliament, to put it in a more dignified manner, and therefore prevents the parliament from making any changes which would effectively be detrimental to the idea of the constitution. And when the Supreme Court lists down the features of the basic structure, the components of the basic structure, and we will see this soon for ourselves, that these features of the basic structure are absolutely essential for the functioning of the state, to the point that you can't do anything without them, to the point that they're invalidated without them. And by restricting the amending powers of the parliament, you have therefore upheld the principles of constitutionalism. So if there's a dedicated question or a smaller question, you've linked it back and your answer is ready. Then comes the correlated question on what is the relationship between basic structure and rule of law. And we understand that rule of law has three components: absence of arbitrary power, equality before law, and predominance of legal spirit. And as far as the basic structure doctrine is concerned, it directly affects absence of arbitrary power and predominance of legal spirit. The idea of rule of law, although is in our Manusmritis, has been in our ancient texts, has been in our Upanishads when we've spoken about how law is the king of the kings. The idea of rule of law comes from France, actually, La Principe de Legalité, goes way back. But a very formal academic articulation of rule of law comes from the British jurist A.V. Dicey, who originally wrote rule of law keeping the British set of things in mind, and therefore in 1885 wrote a treatise of sorts called Introduction to the Study of the Constitution, wherein he's spoken about things like the rule of law. The idea is, when basic structure limits the powers of the parliament to amend the constitution, it does. When that happens, you have restricted the arbitrariness in which the parliament could amend the constitution. And two, if any of these features are violated through a constitutional amendment or an ordinary legislation, we'll come to that, because ordinarily the basic structure doctrine was applicable only to constitutional amendments. Basic structure doctrine says basic principles of the constitution cannot be violated. Basic features of the constitution can only be violated through constitutional amendments. But ordinary legislation also tends to have an impact. So in fact, in the Madras Bar Association case of 2015, and I've listed it down for you, the basic structure doctrine is equally applicable not only to constitutional amendments but also to ordinary legislation, and we'll discuss this at length. And by doing this, you've upheld the principle of predominance of legal spirit, therefore upholding what is called rule of law. And this is enough to write an answer on the relationship between constitutionalism and rule of law in the context of basic structure. Now, although I've explained to you the evolution of it, and you can take the diagram and use it separately, if you had to write it in a smaller context, if you ever had to write it in the mains exam, how would you? You would write it in three parts: the socialist prologue, the constitutional context, and the legal questions, and then basically draw a table out of it. The socialist prologue is, as we've discussed before, it started with a bunch of land reform acts. And these land reform acts were passed by several state legislatures, including Madras, Bombay, etc. And we discussed how these acts were basically aimed at curbing land ownership. And therefore they were challenged at several high courts, as we've discussed. And therefore, the idea was right to property existed as a fundamental right under Article 19, Clause 1, Clause F and 31. And therefore, if you were treating people differently, then Article 14 also stood to be violated. And therefore, several petitions were filed across several high courts, leading to mixed judgments, as we've discussed before. So this could be shrunk into just about 3-4 points and we're done. This led to a constitutional context, wherein in response to this apparent chaos, the Parliament amended the Constitution in 1951. And when the Parliament amended the Constitution in 1951, it added Articles 31A and 31B, which we've discussed, which basically gave immunity to government land acquisitions, and to the 9th schedule giving immunity from judicial review, which you can mention in these 2 points straightforwardly. And then you can lead to the larger legal questions. Now, technically, the constitutionality of land reform acts is also a legal question. But in the larger scheme of things, you have 2 primary legal questions. One is whether law as per Article 13(2), including constitutional amendments or not. And 2, what is the extent of the power of the Parliament to amend the Constitution. And as I said before, when you are giving a sort of a timeline of things, because the outcome, the judgments of Shankari Prasad and Sajjan Singh is the same, you can club them together, followed by Golaknath, Kesavanand, Minerva Mills, Vaman Rao and I.R. Coelho. We got 2 basic legal questions. Constitutional amendments law as per Article 13 Clause 2, they said no. Golaknath said yes, and this is very, very important. And then Kesavanand Bharti overruled Golaknath and said no, and ever since it's been the same. There has been no change. However, the extent of parliamentary powers has undergone some form of evolution. As per Sajjan Singh and Shankari Prasad, they were unlimited. With Golaknath, they were limited. However, fundamental rights could not be amended under any circumstances. There was no distinction between constituent power and ordinary power, and they started applying the principle of prospective overruling. In Kesavanand Bharti, and we'll do this in more detail because that's our star case, it was limited by the basic structure doctrine. It overruled Golaknath a little bit. And among a list of things, it also said basic structure includes judicial review. And categorically, it put a time moratorium where it said pre-1973 insertions to the 9th schedule are not to be judicially reviewed, even if there's a question of violation of basic structure. Now, Minerva Mills effectively reaffirmed what was in Kesavanand Bharti and went back to a pre-42nd Amendment position when it came to the relationship between rights and directive principles, and said 39B and C is greater than 14 and 19. And in Vaman Rao, it also says, not very categorically so, but basic structure applies to amendments and laws applies to the 9th schedule, and I.R. Coelho says, even if they're before 1973, as long as these additions to the 9th schedule violate what is called basic structure, you would still hold them to account. Now, for example, Tamil Nadu as a state has more than 50% reservation, which violates the Indira Sawhney judgment. But because reservation is not basic structure and this Tamil Nadu law is in the 9th schedule, you effectively cannot challenge it. I think the reservation goes up to about 69% or so. Now, we take a magnifying glass and we very specifically answer the next question, which is the 6th question. What was held in the Kesavan Bharti case? Categorically. The 24th Amendment was valid. The 26th Amendment was valid, which is 39B and C greater than 14, 1931, except for the judicial review part. The 29th Amendment was valid, insertion of Kerala state laws. It overruled Golaknath and it said the parliament can amend fundamental rights. And subject to the basic structure doctrine, there is no implied limitation on the parliament to amend anything under the constitution under Article 368 as it is. However, pre-judgment addition, which is pre-1973 additions to the 9th schedule, shall not be considered for judicial review, no matter how objectionable they can be. So, a quick formal listing of what the basic structure doctrine effectively led to. Now, having said that, some special remarks. If the question is about the evolution, these are 3 points that you can write. I found them to be decent enough to be included. First, what we'd already originally spoken in the introduction. The seeds were sown in the Golaknath case. Second, Upendra Bakshi, who's one of the finest law professors of constitutional law in the country, in 1974 had said that Kesavan Bharti is the constitution of the future, actually turned out to be prophetic, turned out to be a prophecy of a certain kind. And in Kesavan Bharti, when the judges were giving you a list of what is basic structure or not, they largely relied on the ingredients of the preamble, the rights and directive principles of state policy, which is a hint for you. If you don't know what are the ingredients of basic structure, just pick up the preamble and fundamental rights and pick up most words from there, especially the preamble, and attribute it to Kesavan Bharti, and that's done. Which then leads me to a very important question: what actually is basic structure? What I've basically done is I've compiled a list, and this is according to certain thematic principles. So first, for example, core constitutional principles. Principles that define the functioning of a constitution. Supremacy of the constitution, rule of law, separation of powers, federalism, and limitations on the amending powers of the constitution under Article 368 of the parliament. Now, more than one Supreme Court case can identify a feature as a basic structure. So supremacy of the constitution was obviously highlighted by the Kesavan Bharti case of 1973 and the S.R. Bommai case of 1994, which by the way is a highlight case for Mains 2024. Rule of law has been highlighted through 3 cases: Indira Gandhi, Indira Sawhney and I.R. Coelho. So it's the triple I, if you want to remember it like that. Indira Sawhney is the election case. This is the case that immediately happened after Kesavan Bharti. So what basically had happened was that after Kesavan Bharti in 1973, and after a sort of failed attempt to overturn it, what had simultaneously happened was that the Allahabad High Court had overturned the Prime Minister's election to the Lok Sabha from a seat in UP. And the Prime Minister went on appeal to the Allahabad High Court judgment. And in the meantime, the nation was put under a state of emergency. And simultaneously, the 39th Amendment of 1975 was enacted by the Parliament, which gave immunity to all presidential, vice presidential and prime ministerial elections from judicial review, and also absolved all past electoral issues of the Prime Minister. This was obviously challenged in the Supreme Court as a very questionable amendment, and the Supreme Court struck down the entire amendment as it is, because judicial review was basic structure, and also separation, and also it violated rule of law, because if you could not challenge somebody's election, then it would violate judicial review, which is predominance of legal spirit. So these are your cases. Separation of powers, 3 cases: Kesavan, S.R. Bommai and I.R. Coelho. Federalism, 2 cases: Kesavan Bharti and S.R. Bommai. And Minerva Mills, is limitations on the amending powers of the parliament under Article 368. That itself is a basic structure, which means this is a very important hint that if it is basic structure that the parliament cannot amend the constitution entirely, that means basic structure is virtually immortal. That's the basic idea. Now, in terms of rights, you've got not the exact fundamental rights, but the principles behind fundamental rights are recognized as elements of basic structure. So Keswanand Bharti and I.R. Kohelo. Secularism through three cases, Keswanand, S.R. Bomai, and this is a new case, Adi Vishweswarai of the Kashi Vishwanath Temple, Varanasi versus State of UP. This is a case revolving around essential religious practices and how management of temples is a secular activity and not a religious activity, and therefore can be regulated by the state. Not important for the mains, but therefore it leads to the larger question on secularism. And because Minerva Mills was about a relationship between rights and directive principles, the balance between fundamental rights and directive principles therefore also happens to be important. The concept of social and economic justice and directive principles as a whole. So concept of social and economic justice is Keswanand Bharti again, and directive principles as a whole is Bhim Singh versus Union of India in 1981. Just a list that you can categorically write in your answers and you're good to go. And as I said before, the objectives which are mentioned in the preamble, we will use this legal status of the preamble much later, was also identified in the Keswanand Bharti case of 1973. Then you have some features which are democracy related, the parliamentary system of government, the principle of free and fair elections, parliamentary democracy, and multi-party systems. Now, the parliamentary form of government is recognized as a basic structure component in the Keswanand Bharti case, which obviously makes sense because of their discussion on the power of the parliament to amend the constitution. The principle of free and fair elections is something that is discussed in your anti-defection case of Quixote Holohan versus Achillo. This is a 1993 case, extremely important because in this case, you argued that the power of the speaker to decide on questions of anti-defection law was not judicially reviewable. In Quixote's case, you struck down that power. In fact, in the official text also, it's very categorically written that the speaker's power is not final because of Quixote's case. Because if that was the case, it would compromise the concept of free and fair elections and therefore would lead a bias reasoning as far as defection questions are concerned. And parliamentary democracy and multi-party systems in the recent judgment of Kuldeep Nair versus Union of India in 2006. And then you have some judiciary related judgments, which I think are the most important for us to generally know. There are effectively 5. Independent and efficient judicial systems. Now you must understand the purpose of this. We will surely get questions on either of these. They automatically become my answers in core questions on these. So if I'm getting a question on judicial review or independence of judiciary, and I could get a question on independence of judiciary because we're looking at 75 years of the Supreme Court and almost 10 years to the NJAC judgment this year. So there is a lot of scope for a question on independence of judiciary for mains 2024, as I would predict it to be. So therefore, I would just write this as a very important aspect of my answer. That independence of judiciary is non-negotiable, as the Supreme Court itself identifies independence of judiciary as a component of the basic structure under so-and-so case. So independent and efficient judicial systems, Registrar Administration versus Sisir Khan Satapathy in 1999. Supreme Court powers specifically under 32, 136, 141 and 142. Delhi Judicial Service Association versus Gujarat 1991. Again, effective access to justice. I would have written this in the Nalsa answer. Central Coalfields versus Jaiswal and Co. 1980. Judicial review, very specifically, 32, 226 and 227. Under Keswanand Bharti, Indira Gandhi, the election case, Minerva Mills, SP Sampath and L. Chandra Kumar are cases pertaining to also independence of judiciary, tribunals and Supreme Court appointments. And independence of judiciary is your third Supreme Court case, which is Supreme Court Advocates Association versus Union of India in 1994. Now, if this is what is basic structure, the fun part now is what is not basic structure. This requires a little bit of understanding. The Supreme Court has also categorically stated there are certain provisions in the Constitution that cannot be construed as basic structure. The first of which is Article 31A, the First Amendment 1951. First things first, how do you think I know this? Let me show you. There are two such volumes of this, and I was able to find this on page 2358 of D.D. Basu, 16th edition, volume 2nd, which is article 152 onwards. This, by the way, is the Ashok Ganguly book. This is the book that I refer to for quotes, which is Nariman, Know Your Constitution. For international comparisons, we've got D.D. Basu, and of course Zia Modi that we had given a reference to in class, and of course MP Jain and the likes. And for general academic references that we've looked at Gautam Bhatia for Transformative Constitution, and of course we've looked at Anomalies in Law and Justice by Justice Ravindran. That's the source of this lecture today. Anyway, so Article 31A, which was inserted by the first constitutional amendment. Now this is and this was decided not to be basic structure in the Vaman Rao case of 1981. Now Article 31A basically says, we remember this, that if the government acquires your land, no fundamental right is violated. Now, technically this is inequality. But the Supreme Court in Vaman Rao said, it is not inequality because it is serving a higher purpose of removing further inequalities due to agricultural land holdings. So an individual's equality versus a collective inequality because of agricultural land holdings. And therefore, this is not basic structure. Article 105 clause 2, this is very interesting in the Quixote case again of 1993. The idea was, under Article 105, our parliamentarians, and of course proportionally through 194, our parliamentarians have a certain set of immunities. And while parliamentary democracy is basic feature, is basic structure, undoubtedly is basic structure, the immunities that are given to parliamentarians are not the same as fundamental rights. Sure, they have lesser restrictions than fundamental rights, but they're not the same as fundamental rights. And therefore they're not the same as having components of basic structure. So this means if I am disqualifying somebody on defection, you cannot come and say parliamentary democracy has been compromised. And if I'm disqualifying somebody on defection on the grounds that they're disobeying the political party they come from, they're speaking against the wishes of the political party, they're voting against the wishes of the political party, they're giving statements or editorials or interviews or acting against the wishes of the political party, if any of those things are the case, you can't take the shield of parliamentary democracy because it's not the same. It's a very, very powerful argument to make. The third thing which is not basic structure that I could find out was Article 334, which was inserted by the 45th Amendment of 1978. At that particular point of time, because while it's about equality, this is affirmative action, which is an extended form of equality. And just because reservation is to be given, a reservation is not a fundamental right, it's a privilege. The Supreme Court, through numerous judgments, has said so. And even if you read the provisions of Article 15 and 16, they're categorical about this, to the point that they're very clear cut about this, in the sense that nothing can stop the state from providing reservation. It does not mean the state has to provide for reservation, and that is the key point. Always remember, that is the key point. So therefore, through Article 334, you basically extended reservation for SCs, STs, Anglo-Indians in state legislatures, and that could not be considered as a permanent feature as basic structure. In fact, in the Supreme Court AOR Association versus Union of India case, the fifth schedule and the way to amend the fifth schedule, I think paragraph AA, it was understood that the fifth schedule could be a temporary provision. And if you're making changes to the fifth schedule, a constitutional amendment under 368 may not be required. And therefore, it cannot be taken up the shield, cannot be taken up under the shield of basic structure just because it is emancipatory in nature, just because it is welfareist in nature, because it tends to give special powers to certain areas, because fifth schedule has two types of areas where PISA is applicable, areas where PISA is not applicable. Fifth schedule applies to about 10 states in this country and certain districts in those 10 states. In PISA applicable areas of fifth schedule, you have a heightened Gram Sabha. In non-PISA areas of the fifth schedule, you have autonomous councils basically. We'll come to that when we do local self-government. Very interestingly, again, in the Sampath Kumar and the L. Chandra Kumar case, we've discussed them in basic structure. Article 323A, which inserted the concept of tribunals via the 42nd Amendment of 1976. So basically, when you inserted the concept of tribunals through 323A, wherein you could have administrative tribunals for service matters, and when you would have administrative tribunals for service matters, then the high courts or the civil courts could not hear service matters anymore. So the powers of judicial review of high courts and civil courts would therefore be diminished. And therefore, if they would be diminished, then in that sense, the tribunals would gain those powers. So you could not question tribunals on the ground that it is violating judicial review, which is basic structure, by taking away the powers of the high court or civil courts. So 323A is not basic structure. And in the very first case, Shankari Prasad in 1951, the court categorically said, if there is an amendment which is being made, which takes away a fundamental right, and now that is no longer a fundamental right, that means you cannot enforce it, which means you cannot go to court for it, which means you cannot judicially review it, that itself is not basic structure. This was held in the Shankari Prasad case. So now we have finished what is called, what has been excluded in the doctrine of basic structure, as we could have categorically answered. Now, once we are done with this, we now move to the next part, which is the analysis, the impact of the doctrine of basic structure. Let's start. Moving on to question number 9. What is the impact of the basic structure doctrine? Now, from an exam point of view, this is where there is a higher probability of the questions being asked, not only because we've surpassed the 50-year mark, but also this is where true analysis lies. Now, the answer to the question, what is the impact of the basic structure doctrine, could effectively be done in two ways. But conceptually, the idea is this, and this could be used all through polity in GS paper 2. We've done this before. Just to put it in context, rule of law has 3 principles: absence of arbitrary power, equality before law, predominance of legal spirit. Each of these 3 principles tend to perform what is called a limiting function. Now, this limiting function is the basis of the principle or the idea of what is called constitutionalism. Now, constitutionalism is about keeping a check or limiting the powers of the government, which therefore leads to framing of what is called the constitution. And there are some basic sort of pillars of what makes an effective constitution. Its intersections with whether it is a written constitution, whether it is in fact allowing for separation of powers and therefore checks and balances, whether there is independence of judiciary, whether there is judicial review, its intersection with parliamentary democracy or the role of the parliament or parliamentary supremacy, and if it's a federal constitution, its impact on federalism. So any principle of the constitution or any idea of the constitution could be interrelated across these six parameters. And even if one of them is asked, you could link it back to the other. So if the question is what is the significance of a written constitution, its impact on separation of powers, independence of judiciary, judicial review, parliamentary supremacy or sovereignty or parliamentary democracy, and federalism, and so on and so forth. Now what happens with basic structure is, basic structure is supposed to perform a limiting function and therefore aids in all of these core pillars of the constitution. And more specifically, because judicial review is a part of basic structure, it also helps you solidify the principles of rule of law, as you've discussed before. And by categorically stopping the powers of the parliament to be unlimited to amend the constitution, you're also helping with absence of arbitrary power. And this also therefore has an intersection with the doctrine of basic structure. So that is the idea. And therefore, when you're answering a question on the impact of basic structure, you could largely do it in two ways. One is a conflict format, and the second is a pillar format. I'll give you both the answers and I'll give you both the structures, whichever you're comfortable with, but this is extremely important. So let's start with this. If you're looking at writing an effective introduction, apart from the ones that I've already discussed with you in the essential and the value addition points, if you want something specific as an effective introduction, you can use the statement that is being given by the Honorable Chief Justice of India, Justice Chandrachud. Now, before I get into the statement, the interesting aspect is that Justice Chandrachud's father was a part of the dissenting bench in Kesavananda Bharati, who then, in a magical turn of events, spoke in the support of basic structure and judicial review in Minerva Mills. And of course, the son, Justice Chandrachud, has made a rather interesting statement. And his son, Chintan Chandrachud, writes about Minerva Mills as the forgotten case of India. So there is a certain lineage of it all. But very recently, about a year or so, Chief Justice of India, Justice Chandrachud, had made a statement wherein he had said that the doctrine of the basic structure is a North Star which sort of guides and gives a clear direction towards the interpretation and the implementation of the Constitution when the path ahead seems to be convoluted, which basically means whenever there is a conflict of constitutionalism, whenever there is a conflict of constitutional values, one must look at the doctrine of basic structure to understand the essence of the Constitution. It is supposed to reflect the absolute soul of the Constitution in a manner of speaking. This statement that was made in response to a statement which was made on the government side, which of course had a further response from the Vice President of India at that time. But that's besides the point, because that's politics. But the idea is the Chief Justice of India basically called the basic structure doctrine the doctrine which guides to be the North Star. Now, when I look at the impact, the first impact has to be a conflict between the judiciary and the parliament. Now, what is the basic impact and what is the basic conflict? As we've understood up until now, Article 368 empowers the Parliament to amend the Constitution, thereby instating what is called parliamentary sovereignty, and thereby handing the powers to the Parliament to amend the Constitution. Now, Article 368 does not define the extent to which the Parliament can amend the Constitution. Article 368, on the other hand, sort of creates classes in which you can amend the Constitution. For provisions which are mentioned directly under Article 368, you would require what is called a special majority too. And if there is an article which is supported by a provision which says an amendment to this article shall not be considered to be an amendment under 368, you would require what is called simple majority. And for effectively everything else, you would require special majority too. So broadly, the Constitution itself identifies 3 ways to change the Constitution of India. But all of it has to necessarily be done by the Parliament. In fact, constitutional amendments can only be initiated by the Parliament, either of the 2 houses. And in fact, constitutional amendments, once passed by the Parliament, must be assented to by the President. It is constitutionally mandated that the President cannot say no to a constitutional amendment bill presented before the President for his or her signature. All of this goes to show that the Parliament is at the center of it all when it comes to constitutional amendments, though the extent of it is not defined in the Constitution at all. And therefore, the Parliament feels that it is bestowed with a larger-than-life constituent power, which has been recognized by the courts in the judgments that we've discussed, as a special kind of a power, as a superpower, different from the ordinary legislative powers under Schedule 7. And therefore, these special powers make the Parliament a special agency to amend the Constitution. Though in some constitutional amendments, ratification of the states is required under Special Majority 3, the initiation of the constitutional amendment must still happen by the Parliament. So therefore, the way we amend our Constitution is also indicative of the nature of federalism in India, which is quasi-federal, but in a unitary format, where the center seems to have a slightly, in fact, more than slightly, edge over the states. It is the same very Constitution through Articles 13 Clause 2, Articles 32, Articles 226, and powers given to the Supreme Court to be constitutional courts to perform functions of judicial review, whether it's from 131 onwards and so on and so forth. But the idea here very simply is that on the one hand, the Parliament has the powers to amend the Constitution, and on the other hand, the judiciary has the powers to protect the Constitution. Now, how do you protect the Constitution? You protect the Constitution by striking down things that could take away from the essence of the Constitution, such as a constitutional amendment. So, in effect, one of the most significant impacts of the Keswanand Bharti case tends to be on the conflict between the judiciary and the Parliament, which is why the very first point that I've given you here is a simple one. And this is a contextual point wherein I've basically tried to explain that while the judgment of the Supreme Court in the Golaknath case was the first sign of judicial supremacy, wherein in Golaknath the Supreme Court categorically said the Parliament cannot touch fundamental rights. Constitutional amendments are law for the purposes of Article 13 Clause 2, and there is no such thing called a constituent power, which means constitutional amendments are to be read as law as per 13.2, and anything which is law as per 13.2 cannot violate fundamental rights. And if that's the case, the Supreme Court can strike such a law down, as in the case of Shreya Singhal, where Section 66A of the IT Act was struck down as violative of Article 19, which is a part of Part 3 of the Constitution. So while judicial supremacy was sought after in the Golaknath case, it was actually in the Keswanand Bharti case where the Supreme Court played a sort of a role of a balancing act, but the ball was still kept in the court of the Supreme Court, where basically the Supreme Court said, while you can amend anything in the Constitution you like, and we're not stopping you at all, but whatever you are amending in the Constitution must not violate certain basic features of the Constitution. Now, in case there is any doubt, what are these basic features, as I've listed them out for you just before this, it is we, the Supreme Court of India, who's going to list down what is a basic feature and what is not. The parliament will not have the authority to list down what is a basic feature or not, because the term basic feature is in a Supreme Court judgment and not in the official text of the Constitution. By the sheer fact that in the Keswanand Bharti case, the Supreme Court allowed the Parliament to amend anything in the Constitution, including fundamental rights. And this is how it also overrules Golaknath to a certain capacity. The Supreme Court did make what I call a strategic retreat over amendments to fundamental rights. But on one hand, while it gave the powers to the Parliament to amend fundamental rights, it also significantly enhanced its powers of judicial review by defining basic structure and conceptualizing it. To the extent of which the Supreme Court also defined judicial review to be an element of basic structure right from Keswanand Bharti's case itself. Indirectly so, but nonetheless. And therefore, it was ultimately aimed to be a balancing act. Now, while the Parliament could amend anything and everything in the Constitution of India, the Supreme Court would also have the powers to amend anything and everything, would have the powers to review anything and anything that the Parliament has amended post 1973 if it was an inclusion in the 9th schedule. So to put it simply, if the Parliament could amend anything in the Constitution, the Supreme Court could also review anything in the Constitution. Of course, the caveat was, if it's a change made to the 9th schedule pre-1973, then the hands of the court were tied as judicial review was restricted, which of course gets sorted out eventually in the I.R. Coelho case of Tamil Nadu in 2007. So, to an extent, our fundamental premise was that the judges wanted to achieve what is called a win-win situation for the Parliament and the Supreme Court. And if the judges wanted to achieve a win-win situation for the Parliament and the Supreme Court, it means the Supreme Court judgment in Keswanand Bharti case was not to be considered as a fiercely one-sided case. How it has been used is a different story, and we'll come to that eventually. But it was ultimately sought out to achieve a balance. The second most significant impact of the Keswanand Bharti case is its impact on constitutionalism above all as an identity. Now, this is a slightly nuanced point, and allow me to indulge you in this. In one of the writings in the law journals, it's categorically mentioned. Keswanand Bharti case recognizes the distinction between the drafting and the working of the Constitution. While the intent of the makers of the Constitution, while they were drafting it, was perhaps not to put any limitation on the Parliament. In fact, on several instances, if you go through the Constituent Assembly debates, you would find that a lot of the things were left to the Parliament to decide. Neither were they expressly prohibited, nor were they expressly allowed. A lot of it was left to the wisdom of the governing parliaments in the years to come. So Keswanand Bharti sort of tries to balance this. When the Constitution is drafted, it is sort of drafted in a vacuum chamber. A vacuum chamber in the sense that it is unaware of how political developments and social developments will pan out in the near future or the distant future to come. But when the Constitution is actually put into place, once the Constitution becomes a fully functioning, lubricated machine that is guiding the country, how the Constitution is used and interpreted by the governments of the day to inculcate policies of the day is a different matter altogether. Which is why there is a significant difference between the working of the constitution and the drafting of it. So this decision in the Kesavanand Bharti case ensured that undoubtedly it is the parliament which has the constituent power above all. And this power that the parliament has is a power because the parliament is the custodian of the trust of the people. But while you have the constituent power to amend the constitution, you should also not have the power to change the fundamental basis of India. Because it is the constitution which recognizes you as the official agent of the state. And it is the same constitution through the preamble which recognizes the people to be the ultimate sovereign of this country. And that is why what Kesavanand Bharti has effectively tried to do is preserve constitutionalism, which is nothing but a limitation on the powers of the state. And therefore, the powers of the state can never be limitless if you are an ardent constitutionalist. More so if you have a constitution, and even more so if you have a written constitution. Because if you have a written constitution with unlimited powers to the state to amend the constitution, then what is the point of a written constitution? Then the three organs of the state, the legislature, the executive, and the judiciary, are no longer going to be equally placed with each other. There is going to be a categorical difference in the powers of the parliament over the rest of the organs. And whatever the power of the parliament might be, it always has to be coextensive with that of the people. Always. Now, this is an extremely important point. The point being, at the end of the day, just because you are in majority does not necessarily means that you're going to do everything in the interest of the majority or everything to preserve the interests of the minority. The interests of the people are ultimately codified in the constitution. And as long as you're able to preserve the constitution in its right capacity, you have as much powers as you need to make any changes to it, to evolve it to a functional document that truly guides us. And beyond this, there are two more points that I'd like to discuss, which is domino effect. If you cross-reference it to the basic principles that we generally study of foreign policy in international relations, one of the primary objectives of the Indian foreign policy has always been to become a sort of a leader of the Southeast Asian regional system, or the South Asian regional system. Today we of course postulate ourselves not only to be a leader of the South Asian regional system, but also of the global South. Now, global South is not as much a geographical term as much as it is a developmental and an economic term, which of course was extremely important last year for the mains and does carry forward to a limited capacity in this year's, and we'll discuss this when I teach IR to you in that capacity. But the idea here is, several of our neighborhoods have seen instances of a military coup which have effectively tried to transition themselves into a dictatorial or a totalitarian rule. Or you have seen governments giving extraordinary powers to themselves over and above bypassing all the other branches of the state. Now, while a judgment given by the apex court of a country is not binding on another country for simple reasons of sovereignty, it still does have persuasive value. You can always take inspiration from a foreign Supreme Court's judgment, customize it or apply it as you would like to the nature of things and to the scheme of things to your own country. So the domino effect has been that India has given an instrument, a mechanism to preserve what is called a sound democracy. an ethical democracy, an accountable democracy to several of its counterparts in and around. Then the second point is the extensive applications of it. The fourth point, sorry. Now let's understand how have we used basic structure across the different genres that we could. Now, directly or indirectly, tangentially or intangentially, either the doctrine of basic structure, the concept of it, or the ingredients of it has often been used to invalidate what is called ordinary legislation. So this is a very, very interesting point. Now, please understand this because this is legally slightly complex. See, the doctrine of basic structure says whatever are the basic features of the Constitution, they cannot be violated. Now the question is, if at all they have to be violated, they would obviously be violated by constitutional amendments. So then therefore there was a very important question, which was, what if an ordinary law, which is not a constitutional amendment, starts affecting basic structure? Because when the Supreme Court strikes ordinary laws down, it is simply performing the function of judicial review. And there are only two ways you can strike an ordinary law down. One, if under 13 clause 2, the law is violating a fundamental right, and to this date, this law under 13.2 does not include constitutional amendments. And second, if the law was made beyond the ambit of legislative competence, the parliament should have not made the law that it did, the state should have not made the law that it did. So technically, an ordinary law may not be able to be subject to basic structure. However, in two Supreme Court judgments closely related to one another, a judgment pertaining to the 99th Constitutional Amendment, which effectively gave the National Judicial Appointments Commission, and in 2015, soon after, the Madras Bar Association case, the Supreme Court categorically stated that even ordinary law is subject to the doctrine of basic structure. So I can question an ordinary law on the basis that it is violating one of the ingredients of basic structure, and that is a remarkable development. And this categorical clarity therefore has a substantive effect. So the NJAC allowed for the creation, the 99th Constitutional Amendment allowed for the creation of an NJAC, which had to be, of course, mentioned in the Constitution, and an NJAC Act had to be created, which would therefore change the way appointments and transfers to Supreme Court and High Court judges were to be carried out. The NJAC Act itself is an ordinary law and would violate principles of independence of judiciary, which is an ingredient of basic structure. So not only did the Supreme Court declare the 99th Amendment to be a violation of basic structure, the Supreme Court also declared the NJAC to be a violation of basic structure, which is an ordinary law. And this is one of the most underrated impacts of basic structure, conceptually rock solid. It was not always the case that ordinary laws were subject to basic structure. It is only after a certain categorical Supreme Court decisions that things have come to where they are. Apart from this, one of the first applications of the doctrine of basic structure was barely 2 years after the doctrine was conceptualized. The political context behind this is the election to the then Prime Minister of India was invalidated by the Allahabad High Court because allegedly the then Prime Minister had used government funds for electoral purposes, rendering an election petition to be duly entertained, and therefore the respective Lok Sabha seat to be declared an invalid election. Now, this was put on appeal to the Supreme Court, and in the meantime, emergency was imposed. Amidst all of this, because the then Prime Minister still continued to be the Prime Minister, the Supreme Court had effectively said that the then Prime Minister, while the Supreme Court had stayed the decision of the Allahabad High Court, had said that the then Prime Minister should not ideally participate in parliamentary proceedings, which effectively is, of course, very embarrassing for the Prime Minister to not be participating in the very house that allows the person to be the Prime Minister. But effectively, the Parliament took the opportunity of this impasse and enacted the 39th Constitutional Amendment of 1975. And the 39th Constitutional Amendment of 1975 basically gave immunity to the elections of the President, Vice President, so that it could seem a little more believable, and of course the Prime Minister. And by doing this, immunity not only from the times to come, but immunity from the times that have gone by. So in the Indira Gandhi versus Rajnarayan case of 1975, the Supreme Court struck down the 39th Amendment lock, stock and barrel for the simple reason that judicial review is basic structure, and the 39th Amendment was violating this basic principle of the basic structure, which is judicial review. In fact, this is also a very similar reason in one of the most popular cases for anti-defection law, Kyoto-Holohan in 1993. Anti-defection law in the 10th schedule, and I've given a reference to this after a couple of pages. In anti-defection law, originally as inserted by the 52nd Amendment of 1985, the decision of the Speaker was final and binding and could not therefore be challenged. This basically limited judicial review. And there was a balance that had to be sought between judicial review and separation of powers. So in Kyoto-Holohan, in 1993, the Supreme Court said, we will not interfere until the Speaker has made her decision. We will not question the procedure that the Speaker has used to come to her decision of disqualifying somebody on the basis of anti-defection law. But the fact that the Speaker would be the absolute final authority is not something which is very digestible to us. Because the high courts of the country, on the other hand, are anyways hearing election petitions. So if we are competent to hear election petitions, we could also be competent to hear disqualification petitions. Which is why, after the Speaker has decided on the disqualification of a person, the aggrieved person can challenge that disqualification in a court of law, Supreme Court or High Court. And the Supreme Court can get into the case without getting into the procedure of it. For a very simple reason, that judicial review is basic structure. And you have tried to preserve separation of powers by not interfering until the decision has been made. Which is effectively why Kyoto-Holohan actually is a case of judicial review as much as it is a case of anti-defection law. In fact, in the official text of the Constitution, which is released annually or biannually with all the updates by the Law Ministry on their Law Ministry's website, which I often tell students to always keep a copy of, in a footnote in the 10th schedule, the Kyoto-Holohan case is mentioned as a tribute to the case. And so is Minerva Mills, and we'll discuss this in a while. So, one of the strongest applications, and this is where things get a little more fine-tuned, one of the strongest applications of the basic structure doctrine has been on upholding the principle of judicial review. That is where things have really taken up to stock. Now, very recently, although Supreme Court has delivered its judgment in the reference abrogation of 370 case, but while the case was being argued by the Supreme Court, argued before the Supreme Court, federalism was quoted as an argument challenging the abrogation of Article 370 way back in 2019. And one of the nature of our federalism in India is that we are asymmetrically federal, which basically means all states are not as equal to each other and all states are not equal before the center. Basically meaning horizontally asymmetrically federal and vertically asymmetrically federal, which we will of course cover in our thematic lecture on federalism. But when the petitioners were challenging the validity of Article 370, the petitioners were effectively challenging that 370 is perfectly invalid because it violates the essence of federalism, which is basic structure. Of course, an argument that eventually did not go through, and the Supreme Court upheld the abrogation of Article 370. Similarly, arguments pertaining to secularism, and secularism is a component of basic structure, we've discussed it in the table before, have been made in the current petitions challenging the Citizenship Amendment Act of 2019. The case is called the Indian Muslim Union League versus Union of India. And in the Indian Union Muslim League versus Union of India, one of the primary arguments is that since secularism is basic structure and the freedom of religion belongs to all people irrespective of whether they're citizens or not, to have a citizenship policy which effectively has a certain positive bias towards people of the non-Islamic faith in general seems to violate the tenets of secularism. Secularism, by the way, was also used as one of the arguments in the Sabrimala case. That secularism also means the ability to manage our religious institutions. And if our religious institutions, through the laws and through their customs, deny the permission of women in a menstruating age group of 10 to 50 to enter the Sabrimala temple, if that's the case, then that's the case. The court, of course, said, well, that is not the case. Secularism has also been argued in cases. Federalism has also been argued in cases. Positively, judicial review has also been added in cases. And if you had to write an apt conclusion to the impact of basic structure, I found this conclusion in a wonderful book written, again, given a reference to that book called Judgments That Changed India by Justice Ashok Ganguly. One of the closing remarks in that book is the closing remarks that one could use. He refers to somebody called Michael Foley. And Michael Foley, in his work, The Silence of Constitutions, say that what is said in the Constitution is important, but it is also important as what is not said, and also what is not said while it is being said. What is written in the Constitution is important. What is equally important is what is not written. And what is also equally important is what is not written while it is written. And to my mind, this is the most beautiful closure one could have to what is called the doctrine of basic structure's impact. The second way, as I was telling you, is to do this on parliament, on constitutional themes. In Mains Magna Carta 2023, I had used a similar format. So there are essentially the following impacts. One is on judicial review, second is on fundamental rights, third is on federalism, fourth is on separation of powers, fifth is limiting constitutional amendments, and sixth is evolution of the constitution. And you can attach contemporary examples that I will discuss with you right now. As discussed before, the first and the most significant impact is on judicial review and constitutional supremacy. which we've discussed in a very great length, that the Supreme Court can review anything, and post IR Coelho can review almost anything in the Constitution. And the Parliament, while has the ability to amend anything, the court has the ability to review anything. And this effectively ensures that the Constitution wins, and therefore everybody eventually wins. So, anti-defection law, NJAC, etc. are some of the examples that you can use for judicial review and constitutional supremacy. With respect to fundamental rights, the idea is that the essence of fundamental rights is basic structure. Fundamental rights per se, verbatim, is not basic structure. This means the Parliament can still amend fundamental rights. They have, in fact, they've removed the right to property through the 44th Constitutional Amendment in 1978, as we've discussed. So that does not mean that the Parliament can't amend. It's just that they can't amend a fundamental right in a way that it affects basic structure. So while there is some flexibility to amend fundamental rights, the essence of fundamental rights, which is basic structure, and we've identified it to be so, that cannot be altered with. That cannot be toyed with. Which is why you can give examples of, for example, Sabrimala, where basic structure was primarily argued. Now, in a written constitution like India, federalism plays a very important role. Now, federalism through the S.R. Bommai case, etc., is recognized, of course, to be basic structure and a certain way of things. Now, what is the extent of federalism that is recognized still has to be decided and discussed on a day-to-day basis. So when you see conflicts between the Lieutenant Governor of Delhi versus the CM of Delhi or the elected government of Delhi, when you see issues pertaining to the abrogation of Article 370, when you hear of interstate water disputes, when you hear of challenges to fiscal federalism, when you hear some inherent issues that could be made better through under the GST regime in terms of allocation and all of those, if you hear of issues pertaining to the principles of devolution as decoded by the Finance Commission, one could eventually argue federalism as a basic structure. For example, with Finance Commission, the basic argument is that the southern states contribute more but get less in return. The northern states contribute less but get more in return, largely because they're more in need for developmental assistance than southern states. But this also turns to be a lack of morale and incentive for southern states to contribute more. So that's something that must keep in mind. Similarly, separation of powers is a categorical ingredient of the basic structure doctrine. So in the again ADL case, in fact, in cases pertaining to tribunals, this has been persistently argued. Most recently in the Matthews versus Union of India case, starting from the El Chandra case. Tribunals have always been a hot bone of contention between the judiciary and the state, between the judiciary and the parliament. The judiciary says that the tribunals are effectively judicial bodies, they're quasi-judicial bodies, but the dominant function is very judicial. So it is the judiciary that must have more control over the tribunals. The government, on the other hand, says, well, they are not full judicial bodies, they're quasi-judicial bodies, and we have set them up for expedited, specialized delivery of justice. And we are the ones who are operationally running them. So we must get more autonomy on how members of the tribunals are chosen. They're not fully judicial because at least half the members are people who are not career judges, who are members of a tribunal. This effectively led to the government abolishing and merging a large number of tribunals through the Finance Act of 2017. But the idea is The issue of tribunals has also been an issue of separation of powers, which is basic structure. The next impact is the impact on limiting constitutional amendments. Now, the idea with limiting constitutional amendments is this. In Minerva Mills, to be very clear on this, the limiting powers, or that there is a limitation on 368, is itself an ingredient of basic structure. The judges in the Minerva Mills, the majority in the Minerva Mills, played it very smartly, and they said, judicial review is basic structure, well and done, good, yes, of course, hooray. But Article 368 itself gives limited powers to the Parliament to amend the Constitution. And Article 368 gives limiting powers to the Parliament to amend the Constitution is effectively one of the most significant improvements in the basic structure doctrine. That means the Parliament, after Minerva Mills, cannot make any changes to 368 enhancing its powers. Which is why I kept on telling you, the Minerva Mills case is the last case which thwarted all parliamentary attempts to gain sort of a supremacy over the judiciary. In Minerva Mills, the Supreme Court itself said that you have a limited power, and that limited power is a part of basic structure, so that limited power is never going to change to a higher power than it is. You will always have a limited power. So the Minerva Mills case becomes an example here. And eventually, when you identify more and more principles and features of the Constitution, you effectively deal towards making the Constitution a more evolved document. At the end of the day, the Constitution is a living, breathing, organic document that guides almost everything that we do on the other hand. Right? So this is the impact, and now we shall move to the critical analysis of having such a doctrine. Moving on to question number 10, which is, what is the critical analysis of having such a doctrine called the basic structure doctrine? Now, of course, the introduction can be the same as Justice Chandrachud's quote, which is basically calling the basic structure doctrine a North Star during convoluted times. But there are basically 3 points that could be written in the answer, which is essentially arguments that criticize the basic structure doctrine. I have put them into a point, subpoint, or a heading, subheading format. The first of it is something that I'd like to call the invisible hand. Now, the invisible hand problem with the basic structure doctrine is basically this. To put it rather simply, the words basic structure are not mentioned anywhere in the Constitution. What is basic structure is not remotely mentioned anywhere in the Constitution. It does not have any textual significance or any textual congruence within the text of the Constitution. If we are a constitutional supremacy in a manner of speaking, and if we are in a manner of speaking a written constitution, then whatever has to guide the future of the country should emanate from the written constitution. And if something is not written in the constitution and is therefore arduously followed, it defeats the purpose of having a written constitution. And also at the same time, if the advantage of it is being taken by the judiciary, then that also does not seem to be a very fair point. And ultimately, across Supreme Court judgments and across major evolutions in the Constitution, whenever we have been stuck in a flux, wherein we have been able to figure out what is the meaning of X provision, what is the intent of X provision, what is the idea behind X provision, we have often gone back to the Constituent Assembly debates to understand what exactly is it that the members of the Constituent Assembly wanted to do when they inserted such a provision or didn't insert such a provision. In fact, insofar as the reading of the Constituent Assembly is concerned, even a remote mention of the basic structure doctrine in any form, or limitations of the power on the power of the Parliament in any form, are not even rarely discussed. So one can safely say that the framers of the constitution did not intend to have what is called the basic structure doctrine. Point number 3, there is inherently a nexus between the doctrine and the constitution. The idea is that the constitution is a codified one. Now, the second you start giving more focus to what is actually in the basic structure, you take away from the codification value of the constitution, which is basically undermining the spirit of the written constitution. You're not following the text of the law, you're following the spirit of the law if you assume the spirit meant to give the parliament some limitation on the amendment of the constitution. Second, nobody understands this better than UPSC aspirants. If it is lengthy beyond a point, then it sort of loses the point. My second primary argument against the Keswan and Bharti case is that it is sort of lost in transition. In fact, it is one of the only cases that have been recorded in Indian legal history which had an official summary to have been released by the court. And several judges, in fact, refused to sign the summary of this case. Even till today, there are questions raised on what exactly is the majority. The case transcends to about 4 lakh plus words written in more than 700 odd pages. And there are 11 separate distinct opinions that have been ushered in as far as this case is concerned. And therefore, to very accurately pinpoint this is exactly what the case intended to say or the case intended to deliver is in fact rather difficult. Now, unfortunately, what happens because of this is it leads to a classic case of an outstanding study on the lack of consensus, which I think for dramatic purposes I have mentioned here in the first point. The problem with having such a diverse case, in fact, it is one of the lengthiest cases recorded in Indian legal history, in fact, the lengthiest, if not one of the lengthiest, is that whenever there is a lack of clarity in what the case actually meant, one cannot accurately apply the case in forthcoming cases, thereby also questioning the Supreme Court's ability to be a court of record. Secondly, because you have such a diversity of opinion, it sort of tilts more towards the individualization of the case than the collectivization of the case. Each of the 11 judgments, 11 opinions that we have discussed are actually dependent on the personal preferences and the personal opinions of the judges as to what they individually think is right. But the idea was that 13 judges came together to collectively solve the problem as to what extent can the parliament amend the constitution. And therefore it becomes a rather complicated problem to solve. Third, it fundamentally questions the very idea of democracy. So the idea was that the parliament is a representative of the majority, and therefore the parliament gets to decide what needs to be done with the future of this country. Now, if the parliament in their wisdom believes X as a feature of the constitution is no longer relevant, or Y as the feature of the constitution is no longer necessary, then what it sort of tends to do is to counter the democratic mandate of the parliament. And this in fact causes what is called a democratic imbalance. And this democratic imbalance places constitutional amendments at the mercy of the Supreme Court, which, by the way, is an unelected self-appointed body. for all the great things that the Supreme Court has done for this country, we must always remember that we are the only Supreme Court in the world where summarily and exhaustively the judges effectively appoint themselves. And if the judges are to appoint themselves in the way that they are to, an undemocratically institutionalized body is questioning democratic practices, however good or bad they were. Whether what the parliament wants to do is for the inherent good or bad for the country is ultimately judged by the Supreme Court, which is basically a qualitative assessment of democracy, which, according to many thinkers and scholars, goes against the principle of separation of powers. Whether the majority is right or wrong inherently and moral or immoral inherently is ultimately for the people to decide. It is not for the court to decide as to whether the judgment seems to be constitutionally sound or not. And that's why the things tend to get a little more out of hand. Which then automatically leads to the next question, which is a follow-up, which is, can the basic structure doctrine be amended or diluted? Now, this was a question which, in a more extrapolatory form, was asked in 2019. But there is a very good possibility that this could be a part of a larger question in 2024. And therefore, what one must understand in that format is this: that if you have to amend or dilute basic structure, there are multiple ways to go about it. Theoretically, of course, because practically it seems to be quite an impossibility. The initiating point or the inaugural point with this is, how do you dilute or amend something in the Constitution which is not in the Constitution? Basically, the basic structure doctrine is intangible. And because it's intangible yet has such an important impact, how do you change something that you can't touch? That you can't physically say this is a part of the Constitution and this is not. Because technically, if your question is the basic structure doctrine a part of the Constitution? The answer is no. It's not written anywhere from a textual point of view. So, a constitutional amendment therefore cannot be passed reversing the basic structure doctrine. A constitutional amendment may be passed enhancing the powers of the parliament, which also now becomes difficult post Minerva. But there cannot be a constitutional amendment reversing the basic structure doctrine, because there is no such thing called the basic structure doctrine in the Constitution of India. So therefore, the only means that you're effectively left with are extra constitutional measures, measures beyond the Constitution, measures that go above and beyond the limits that are in the Constitution or the provisions in the Constitution. So when you have two basic questions, can I repeal the basic structure doctrine? Or can I change, say, the parliamentary system of government is a basic structure doctrine? Can I replace the parliamentary system of government with a presidential system? Is that theoretically possible in the country? Both of these questions have the same answer. Can I replace the basic, can I remove the basic structure doctrine? And can I do something which changes the core principles of the basic structure doctrine? Theoretically, these are the options that we have. The most dramatic option, and this option called the revolution, is mentioned in the second volume of the great constitutional author D.D. Basu. And he identifies 3-4 basic ways, one of which he says is revolution. Revolution, as we understand, is a complete state of chaos. Revolution has no legal standing, but in fact has a moral and a political and a civic standing. In a written constitution, to accommodate for revolution is just impossible. But one of the ways theoretically would be just going all out, as listed by D.D. Basu. Second is if you go back to where it all started, it all came down to the idea that the Constituent Assembly was effectively not in a space to do X number of changes to the amending powers of the Parliament. The idea is a very simple one. What if you could resurrect the Constituent Assembly? Now, by resurrection of the Constituent Assembly, I do not mean giving rebirth to the members of the Constituent Assembly, of course. What I do mean is, can the Parliament convert itself to become a Constituent Assembly? And if the Parliament can convert itself to becoming a Constituent Assembly, and then redrafting the Constitution entirely, and then saying, this is exactly what the Parliament can do, and this is exactly what the Supreme Court can't do. That is a theoretical possibility. Now, this theoretical possibility becomes impossible because if you look at the ingredients of the basic structure, the Supreme Court, as I told you before, very smartly, in the Minerva Mills case said that the limited powers of the Parliament to amend the Constitution are also ingredients of the basic structure. The limited powers of the Parliament to amend the Constitution is also basic structure. And therefore, unquestionably, you have absolutely no way that you can give more enhanced powers to the Parliament. Third is a grand concept called referendum, which is effectively a tool of direct democracy. To know more about what direct democracy is, you can refer to the Magna Carta Foundation lectures, which will be on YouTube from the 7th of July onwards. And in theme number 1, in the layout of the Indian state and the approaches to state systems, I've discussed the tools of democracy, and you can do a detailed understanding of it should you need to. But the basic idea is the referendum. A referendum as a concept is where the government officially walks up to the people directly and asks their opinion on anything in the world. Now, the legal status of referendum in India is a fairly simple one. Neither do we have a law against referendums, nor do we have a law supporting referendums. Now, to execute a referendum, you would have to take it to the people of this country, which, given the fact that people have a greater faith in the judiciary and they look at the Supreme Court as the knight in shining armor, and the Supreme Court through various judgments and the higher courts in general have in fact filled the void of parliamentary delays and to a large extent incompetency of the Parliament, the likely outcome of a referendum is going to be slightly more difficult. The next way to do this is possibly to have a higher bench. Now, this was technically possible and was also attempted once in 1975. It was technically also possible before the Minerva Mills case of 1980. As I said, because Minerva Mills now anyways puts limitations as ingredients of basic structure. So while a bench to review the Keswanand Bharti judgment was set up, magically and rather conspicuously, the bench was dissolved within a matter of a few days. There's officially no reason as to why this happened. And this is also because the country was in the state of an emergency and there were restrictions on the media to report proceedings of the court. And therefore, one never really got down to knowing whether this was actually possible or not. Over a period of time, and all of this is pre-Minerva, and this is why I keep saying Minerva Mills is incredibly underrated. And Chintan Chandrachud, Saab, in his book called Cases That India Has Forgotten, rightly so says, Minerva was a master stroke that we don't recognize as much as we do as far as we recognize Keswanand Bharti. It's not nearly as celebrated as Keswanand Bharti is, and it should be nearly as celebrated. There were attempts made through the 25th, 42nd and the 44th amendments to effectively give either enhanced powers to the parliament to amend the constitution or to reduce the powers of the judiciary to perform judicial review. In either of these cases, the 25th, the 42nd, and the 44th Amendment, provisions which were to reduce the powers of the Supreme Court to perform the function of judicial review was in fact categorically struck down. Yes, supremacy was given to two directive principles eventually over two fundamental rights, 39B and C is greater than 1419 today. And we will study this in greater detail in the context of Minerva Mills and, of course, property rights. But the idea is a fairly simple one, which is now it is almost impossible, especially after post-Minerva. So then the question becomes, can you change Minerva? Can you take away an ingredient out? If Minerva says that limitations of the parliament to amend the constitution is basic structure, can I remove this ingredient through a further judgment? Well, that is theoretically possible. So to my understanding, this is the only way that you can somehow damage basic structure. And this is your answer to the question as to whether basic structure can be amended or diluted. And just for a sprinkling reason, in case we get a larger answer, and in case at the top of our hat we get a question on comparing amendability powers of different countries of the world, though if there has to be a specific question, it has to be US, UK and France, and basic structure cannot be asked as a single question. But if you have to write an answer and you have to write a few points on how basic structure works elsewhere in the world, there are basically three ideas that I want to discuss. Three places where we have to understand, if you're looking at internationalization of basic structure, we have to understand in two components. One, the amending powers of various constitutions, where we look at US, UK and by extension Australia. And then we look at how the concept of basic structure is now in fact a global concept. Both of these are extrapolatory points, value addition points that you can use if you wish to change your score beyond a 120, which I think you really should. Now, as far as the Constitution of England is concerned, it is primarily a written constitution. It's primarily an unwritten constitution. And just to get your basics right, just because something is unwritten does not mean it's not written at all. When we say the Constitution of England is unwritten, it means it is written in 10 different ordinary laws, which have the status of having constitutional laws. And UK, because there's no single written law, you don't have a single written constitution. The Parliament of UK can single-handedly strike down any constitutional law using the same simple majority as it would have for any other ordinary law. So in the UK, you could say there is no difference between a constituent power and an ordinary power. So therefore, when you don't have a written constitution, it would have a drastic impact on amending the powers of the constitution, because there is no such thing called a written constitution. What we're effectively looking at several constitutional laws which are the same things as ordinary laws. For example, the Human Rights Act. For example, the Union Act of UK, which is basically an act which governs the Parliament of UK. So therefore, what really affects an unwritten constitution are basically constitutional values. And these constitutional values and the doctrine is very tangentially having an impact in England. Because even if, let us say, let's say separation of powers is basic structure in UK, there must be an ordinary law which talks about it. You can change that law. What really happened in the UK, now this of course today is back to square one, is Brexit. Now, as we know that the UK elections have been completed and Sir Starmer now is the Prime Minister of England, and the UK has seen about, if my memory serves me correct, I think it has seen about 5 Prime Ministers in 14 years, which is rather exciting for the mother of democracy in the world. But the idea is when the UK was a part of the European Union in a certain capacity, it was bound by certain regulations of the European Union, which it had no choice but to adhere to, which eventually led to the enactment of the Human Rights Act of 1998. And that had acquired the status of a constitutional doctrine. And no law made in England could violate the general human rights principles of the European Union. In a way, there was a degree of constitutionalism in a larger capacity. But post-Brexit, it's all back to square one. It is the American Constitution that we must pay heed to. See, the idea here is Article 5 of the American Constitution allows for the amendment to the American Constitution. Between the American, Australian and the Indian Constitution, we've had the most number of amendments. As of today, we stand with more than 100 constitutional amendments in less than 75 years. America has not even had 30 amendments in more than 200 years of its independence. That means it is easier to amend the Indian Constitution than it is to amend the American Constitution. Despite the fact that the American Constitution is a shorter constitution than the Indian Constitution. Significantly shorter. So the majority which is required to amend the American Constitution is also higher. First things first, 2/3 of both the houses of the American Parliament, which is called the Congress, have to pass the same. And then 2/3 of the state legislatures have to call for a constitutional convention. And post that, 3/4 majority is required by the states or by the state conventions to amend the American Constitution. And there are certain parts in the American Constitution that cannot be changed. For example, no amendment can deprive the equal voting rights that have been given to the states in the American Senate, which is their upper house. So there are two things very interesting about the American Constitution. A, it is tougher to amend. And B, it has certain principles that cannot be changed. What cannot be changed is also categorically written in the American Constitution. With the Australian Constitution, things are even a notch forward. Basically, after an absolute majority in each house, for an amendment to the Australian Constitution, you would require a national referendum to pass that amendment. Which means the people of Australia have to directly approve a constitutional amendment. This is perhaps where D.D. Basu gets his idea of a referendum. But the idea is a fairly simple one. This means a constitutional amendment in Australia seems to be one of the most difficult pieces of legislation that can be passed, which is why it has one of the least number of amendments in the world. What we have in India as scheduled tribes are called originals in Australia, also called aboriginals in Australia. And the Australian government has been struggling to provide them with greater benefits in the constitution, simply because the procedure that is required to initiate such protections is very difficult to get through. But the idea of having limitations is a universal one. One of the reasons we keep on looking towards the Irish Constitution is that when we became independent, the Irish Constitution was the most recent constitution in the world. It was the most contemporary constitution that we could take inspiration from. The Irish Constitution was no doubt a Catholic constitution, which means the Pope would have a certain number of calls to make with respect to the Irish Constitution. But very interestingly, apart from the fact that the Irish Constitution gave us the idea of directive principles, the Irish Constitution had a very interesting set of provisions for amenability. For the first decade or so, the parliament was allowed to make any changes to the Irish constitution to make it a stable, functional document. Post that, there were certain principles of the Irish constitution that even the Parliament of Ireland could not amend. So a temporary makeshift arrangement has also been seen by the countries of the world, which therefore makes me understand how global is the idea of basic structure. If you look at the constitutions of Portugal and Greece, and these are just one-liners for your mains exam, both of these constitutions have a list, an explicit written down list of provisions that cannot be changed by anyone. Countries such as Italy and France don't have a list as exhaustive as Portugal and Greece, but have in fact tried to protect 2 or 3 very, very significant features of the constitution, such as separation of powers, or maybe a republican form of government or a presidential form of government. In fact, our not so beloved neighbor Pakistan in 2015 has also recognized the concept of implied limitations and has placed restrictions on parliaments, on Pakistani parliament, to amend certain provisions which could be overturned by the judiciary. And in fact, Pakistan has declared judiciary, democracy and the parliamentary form of government as their basic structure. Which is why, post the Musharraf fiasco in Pakistan, the possibility of a military coup in Pakistan, if rule of law is still upheld in some form in Pakistan, seems to be a very distant possibility. In a rather notoriously famous country called Thailand, which by the way has one of the best health systems in the world and education, primary education systems in the world, apart from things what it's most obviously known for, unfortunately, there is no specific mention of the word doctrine. But they also in their constitution have a list of unamendable features. Australia has also done the same. And very interestingly, the courts in Britain have also started to articulate and synthesize that is there something so fundamental that even the sovereign supreme British Parliament cannot really effectively get into. And this brings me to the question on limitations on the amenability of the Parliament, which is my second last question of this particular lecture, which is, what was held in the Minerva Mills case and why is the case important? So let's understand this. While the Minerva Mills case is yet another milestone, which basically prevents the Parliament from overriding certain basic structure provisions such as judicial review, and it tries to reaffirm what was held in the Kesavanand Bharti case. And what the Parliament basically wanted to do was pass a not little amendment called the 42nd Amendment of 1976. The impact of Minerva Mills is greater than what it is often given credit for. Minerva Mills was a textile mill in Bangalore in Karnataka. And the government had nationalized Minerva Mills under the nationalization policy and had passed a nationalization act, and through that act they basically took over the operations of Minerva. Now the idea behind this is actually a more simple one. Remember, we were talking about articles 39B and C, prevention of concentration of wealth and equal distribution of resources. A government policy of nationalization, which means the government is basically going to run a particular entity, is a way to implement articles 39B and 39C. Because if nationalization is an element of socialism, and if the government is running an industry, then the benefits have to be more equitable in nature. Now, what the 42nd Amendment did was, if at all the government did anything to implement directives under 39B and C, and your only objections to this was 14, 19 and 31 back in the day. 31 through the 78th Amendment also gets thrashed out. Then there shall be no judicial review of this. Nationalization is an implementation of 39B and C. And by singling out Minerva Mills, you're treating Minerva Mills unequally before the Nationalization Act, which was necessary to give execution to the nationalization policy. And Article 19 also has the freedom of occupation, trade and business, which would also be violative of Article 19 through the Nationalization Act. And if it is about concentration of wealth and resources, it would ultimately also lead to the larger issue of land, which today in 2024 is a major Supreme Court issue that we are currently looking to understand. This Nationalization Act was also added to the 9th schedule. And since nationalization is not basic structure, it could not be challenged. So there were two reasons why this Nationalization Act was in a very unique legal position. One, because of the 42nd Amendment, and two, because this act was placed in the 9th schedule. And nationalization is not basic structure, and whatever is in the 9th schedule, if it violates basic structure, could be judicially reviewed, even if it's, and this is post 1973. It's only in 2007 where pre 1973 also applies. So by limiting judicial review via the 42nd Amendment, this particular part, the 42nd Amendment was challenged under Article 32. Because if you're limiting a person's judicial review, you're limiting a person's right to approach the court, which is a constitutional remedy under Article 32. And hold on a minute here and understand this. No law can violate a fundamental right under Article 13, Clause 2. Nationalization Act is a law, cannot violate a fundamental right, but that law is protected in the 9th schedule, so we are stuck. But you've got to give it to the vision of the makers of the Constitution, wherein categorically, absolutely categorically, Article 32, which allows anyone to go to the Supreme Court if they want to, directly for a fundamental right violation, is mentioned in Part 3. This is technically Supreme Court jurisdiction. This is technically Supreme Court powers. But Supreme Court powers and Supreme Court jurisdiction is actually mentioned in Part 3 and not anywhere else. It is mentioned in Part 3 and not anywhere else. That means Article 32 itself is a fundamental right. So on that basis, an Article 32 petition was also filed. And the basic validity of the 42nd Amendment Act was challenged. And what was specifically in the 42nd Amendment? Three very specific things. One, it added a line to Article 31C, which basically said that, and this is the important part, through the 42nd Amendment of 1976, instead of just 39B and 39C as violative, it upgraded it to saying all directive principles of state policy are greater than 14, 19 and 31. So nationalization got all the more push. And this is nothing but giving more free hand to the government. Insertion of 368.4 and 368.5, two provisions, both of them have been struck down, were to basically reduce the powers of the court to judicially review. Now let's understand this. According to the newly inserted clause of Article 368, Clause 4, any amendment which was made under Article 368 could not be challenged in a court of law on any ground. This is basically undoing everything that Kesavan Bharati said. That a constitutional amendment can do anything to the constitution and the courts cannot review it. Then what is the point of the basic structure doctrine? And just to settle the record straight, they also added 368(5) and said, according to the new clause, there is no limitation on the constituent power and you can change whatever you want to in the constitution, which is basically the extra constitutional method that I was talking to you about. This is why Minerva Mills is very important, because post Minerva Mills, this is no longer a legal possibility. So therefore the outcome was a very simple one, that 368(4), 368(5), which was inserted by the 42nd Amendment to Section 55, were declared unconstitutional and was reinstated, reaffirmed, reiterated that judicial review is in fact basic structure. And the court reversed it back to the pre-42nd Amendment, which means still 2 directive principles are superior to 3 fundamental rights. That's the basic idea. That's what it all went back to. Before 1976, 2 directive principles were superior to 3 fundamental rights. Post 1976, all directive principles were superior. To put it this way, pre-42nd Constitutional Amendment 1976, 39B and 39C were greater than 14, 19, 31. Post 42nd Constitutional Amendment 1976, all directive principles of state policy greater than 14, 19, 31. 44th Constitutional Amendment 1978, no right to property. In both of these cases, no judicial review. Minerva Mills says 39B, 39C greater than 14 and 19, 31 is now deleted, and hell yes, judicial review. That's basically what the game is. So even till today, 39B and 39C are greater than 14 and 19, which is why land becomes such an issue in 2024. So if this is what was held in the Minerva Mills case, the question is, why is the case important? What is the impact of it? Apart from, of course, establishing a relationship between rights and directive principles, because ultimately you're looking at a relationship between 39B and C and Articles 14 and 19. These are directive principles of state policy. These are fundamental rights. There is a relationship of some kind. The most significant impact of the Minerva Mills case is it provides limitations on the Parliament to amend the Constitution under Article 368. And it provides for a balance between rights and directive principles, therefore institutionalizing a concept called the doctrine of harmonious construction. That as much as possible, try to keep a harmonious relationship between rights and directive principles. This also has a federal meaning. This also has a Schedule 7 meaning. But a large component of the doctrine of harmonious construction has to do with the relationship between rights and directive principles. Now, very interestingly, technically nationalization seemed to be okay because prevention of concentration of wealth and natural resources, wealth and resources. The owners of Minerva Mills continued to contest this for many, many years. And finally, in 1986, the Supreme Court put an end to the whole nationalization debate. So a harmonious balance between fundamental rights and basic structure and directive principles is also a component of the doctrine of basic structure. But what Minerva Mills effectively does is that it sets the tone for the future of the basic structure of India, where basic structure has to always play a neutral role. And more than 4 decades after the judgment, and this is just an extrapolatory point, when you download the official text, as I was telling you in Quixote's case, and if you read Article 368 in the footnote, Article 368.4 and 368.5, of course, have been struck down by the Supreme Court, and there's a small little tribute to the Minerva Mills case. And as I was telling you, Chintan Chandrachud, the son of the current serving Chief Justice, in his book, The Cases That India Forgot, refers to Minerva Mills as the first case, because it is effectively this case that really puts a lot of shape, form and integrity to basic structure. It's because of Minerva Mills that a balance between rights and directive principles is basic structure. Limitations on the amending power of the parliament is basic structure. And judicial review reaffirmed is basic structure. So in a way, Minerva Mills was the last battle. And just on a side note, through the legal history of this country, इस देश में 3 ऐसे मौके आए हैं. There have been 3 instances in this country where the judiciary and the parliament, and parliament includes the government, there have been 3 instances, 3 ऐसे मौके आए हैं where the judiciary has been at loggerheads with the parliament. First is supremacy of the parliament, judicial review, basic structure, fundamental rights. Second is with reservation policy. And third is with the state of minority institutions. इन तीनों केसेस में पहले 2 केस में एक तरह से जुडिशरी की जीत हुई है. मतलब प्रॉपर्टी राइट्स और ये अमेनेबिलिटी ऑफ फंडामेंटल राइट्स और बेसिक स्ट्रक्चर के केस में जुडिशरी की जीत हुई है. माइनॉरिटी में जुडिशरीज हैड सॉर्ट ऑफ द फाइनल से, बट रिजर्वेशन पॉलिसी में द गवर्नमेंट हैज हैड द फाइनल से. Basically, to put it in simpler context, there have been 3 occasions of a grand confrontation between the judiciary and the parliament. First has been with respect to the amenability of fundamental rights. Second has been with respect to reservation policy. And third has been with respect to minority institutions. And in each of these 3 cases, there has been a clear-cut person who's had the last say, the last laugh, the last say, the last role. This battle goes to the judiciary. The minority institutions battle goes to the judiciary. TMA, Pai, Pramati, Inamdar, all of those. And the reservation battle goes to the parliament or the government. That's effectively what I was trying to say. So the impact of the Minerva Mills case has been far more than what it is often given credited for. And ultimately, it is often talking about a relationship between fundamental rights and directive principles, which I thought could be a theoretical question, as it is often asked out to be. So I put it in 3 parts. There is a diagrammatic representation, which is nothing but a sub-part of the larger timeline that I've already showed you. And there are certain points that you should write. The context is, you must first identify the constitutional position of fundamental rights and directive principles. The directive principles differ from fundamental rights which basically enjoin the state from refraining against prejudicial action, which means the fundamental rights are basically negative obligations on the state. They're stopping the state from taking away your fundamental rights. And therefore, fundamental rights are seeking more of an egalitarian, a more equal society, attempting what is called liberty for all. Directive principles, on the other hand, seek to achieve what is called a welfare state, where you are counting on the state to do something more for the betterment of the people. You're nudging the state through legislation, executive, and other forms of policy to implement certain grand ideas that is going to make the life of the community, society, and nation better. And that is why more often than not, both of them are collectively called the conscience of the Constitution. In fact, one of our favorite textbooks in constitutional law is a book called MP Jain, and Jain Saab very categorically writes that the preamble, fundamental rights and directive principles can be characterized as the trinity of the Constitution. Now, if the idea is fundamental rights and directive principles should not be looked as enemies of each other, what they should be looked at are basically things that make each other better. You should have freedom of religion, and you should also have uniform civil code. You should have socialism, and you should also have the freedom of occupation. There has to be some form of settlement and normalcy between the two. However, there are some categorically key differences. The first and the foremost is a very basic one, that directive principles are not enforceable in a court of law, but they can be enforced in a parliament. They can be enforced in the states. They can be enforced by the ministries. It's just that you can't take the government to court if they don't implement a directive principle. And therefore, there are no justiciable rights in directive principles. In fact, what directive principles have are non-justiciable rights, such as legal aid, equal pay and equal work. And a few of these non-justiciable rights and directive principles, by the way, through Supreme Court judgments have been made to be implied fundamental rights also, therefore showing how inherently complementary directive principles and rights can be. So the only way to really give some teeth to directive principles is to implement them by law. And as long as there is no law, carrying out the policy which is laid down neither in the directive, or if the government has not done anything to implement it, there's really nothing an individual can do. You not implementing a directive does not violate the legal right of any individual. This has also been reaffirmed by the Supreme Court very early on in Mangru versus Commissioner of Bajbaj in 1951. The details of the case are rather funny, so we'll not get there. And the directives per se do not confer any form of legislative power. For example, one of the directives is promotion of cottage industries. So whoever has the legislative competence to regulate cottage industries will make the laws on cottage industries. For example, if it is a directive principle to do with, say, nutrition and healthy living, health is in the state subject. There is very little the parliament can legislatively do about health. It is in fact the states who will have to make health related laws, as Rajasthan very recently did by passing the Right to Health Act. So just because something is in the directive principles does not automatically mean everybody has a field day to do whatever they want to implement it. Those who have the competence to implement it are the only ones who can implement it. And that is why the courts can never declare any provision void or any provision problematic on the grounds that it convenes any of the directive principles. And that is the key of it all. That is the key of it all in the sense of it as it should be. And diagrammatically, this is sort of the relationship between directive principles and fundamental rights. This is nothing but a derivation of the large diagram that I've shown you. This is something that we'd used last year as well. Starts from the Champakkam case, goes to Kerala higher education, and very categorically in both of these cases, it's fundamental rights over directive principles. They try to say there should be some form of harmonization. In Golaknath versus Punjab, again, fundamental rights over directive principles. The 42nd Amendment sort of tries to also nullify Golaknath by saying 39B and 39C. And then the 25th Amendment happens, which says 39B and 39C are greater than 14, 19 and 31. And the 42nd Amendment then says all fundamental rights are great, or directive principles are greater than fundamental rights. We'll come to that. So, in Golaknath, the status remains the same. Fundamental rights are superior to directive principles. To the 25th Amendment Act of 1971, which attempts to nullify what Golaknath has done in every form, manner or capacity, the 25th Amendment Act of 1971 inserts a new little amendment to 31C which says 2 directive principles are greater than 3 fundamental rights, which is 39B and 39C, which is about prevention of concentration of wealth and equal distribution of resources, to be greater than Articles 14, 19 and 31, which by the way is the birthplace of something called the property rights issue that we are discussing today. And therefore, this Article 31C becomes problematic because not only does it give precedence to 2 directive principles over 14, 19 and 31, it also negates judicial review, and this part is overruled in the Kesavananda Bharati case. And through an amendment to 31C in the 42nd Amendment of 1976, from 2 directive principles, it becomes all directive principles as we've already discussed. Minerva Mills takes it back to the 25th Amendment position. And again, the no judicial review part is struck down, which was added by by Article 31C. And finally, in 1993, the Supreme Court in a remarkable judgment says, fundamental rights are the means through which the goals of Part 4 are achieved, which is Unnikrishnan versus the state of Andhra Pradesh in 1993. So basically what they're effectively trying to do is to perform what is called a balancing act. And there are several judgments that support this in a very, very important case, because this absolute concept of the relationship between directive principles and fundamental rights not only applies to nationalization, it also applies to, let us say, reservation policy. It also applies to the nature of property rights, which is an important Supreme Court judgment pending in 2024. Simply because of the relationship between directive principles and fundamental rights. So State of Kerala in N.M. Thomas, which is basically a reservation judgment, tends to get into this. And the balancing act is as follows. So the balancing act, as we were trying to understand it to be, for example, in the Supreme Court case of State of Kerala versus N.M. Thomas, which is basically a reservation judgment of 1973, very categorically stated that the directive principles and fundamental rights should be construed in absolute harmony with each other, and you should try to resolve any form of animosity between them. And in one of the greatest cases that India has seen, the Olga Tellis case of 1986, the Supreme Court is, and this was a prelims question also, by the way, is the Supreme Court categorically said the directive principles are fundamental to governance in the country, therefore reiterating one of the directive principles. And therefore, if you have to understand the meaning and interpretation of fundamental rights to be done better, you must really take directive principles into account. A way to understand this is for you to understand the dimensions of Article 14. You must look at the practical applications of equality, which is mentioned under Part 4, which is directive principles. And therefore, instead of the Supreme Court being an obstacle, the Supreme Court has in fact taken upon itself to use this opportunity to make a few directive principles the status of implied fundamental rights. For example, if you look at the Unnikrishnan case, it is in the Unnikrishnan case where the court in 1993 had said the right to education therefore should be a fundamental right. And effectively Article 21A was enacted by the Constitution through the amendment in 2003. In fact, in Randhir Singh versus Union of India in 1982, equal pay for equal work, which was originally a non-justiciable right, today is considered to be an implied fundamental right under 14 and Article 21. And in Hoscott versus State of Maharashtra in 1978, legal aid and speedy trial are fundamental rights under Article 21 and should always be available to all prisoners and can be enforced. Which means if somebody is not able to afford a lawyer to represent themselves in a court, it is the responsibility of the court to ensure that there is a lawyer, which is why you have the Legal Services Authority Act, and both the Supreme Court and the High Court are respectively in charges of ensuring legal aid at the central level and at the state level. And therefore it becomes very important to understand how beautifully harmonious fundamental rights and directive principles can be. And an application of fundamental rights and directive principles is property rights. We've understood why that is the case. If directive principles and fundamental rights could be understood through the lens of property rights, simply because the current equation is 39B and 39C are greater than 14 and 19. Previously 31, which used to be a property right, was also included in this equation. 39B and 39C tries to prevent concentration of wealth and equal distribution of resources. And both of these could very well be implemented through land reform or let us say through land acquisition. And both of these would effectively have an impact on what are called property rights. So the last question that we have to cover as far as this particular topic is concerned is what is the nature and state of property rights and why is the Supreme Court getting into this? So right now in 2024, final arguments have been completed in the case of Property Owners Association versus State of Maharashtra, and the Supreme Court is basically going to decide if private property can be considered material resources for the community in general under Article 39B. 39B, as we know, is superior to Article 14 and 19 if these are the only objections. For that, we must first understand the evolution of the right to property. Now, we know that the right to property is no longer a fundamental right and in fact is a constitutional right and a legal right. But the original text of the Constitution was fairly clear. We know that the right to property was removed from the Constitution as a fundamental right by the 44th Amendment and was inserted elsewhere in the Constitution and was made the status of a constitutional right and was no longer a fundamental right. Now we'll understand how that effectively works. The original text of the Constitution had the following provisions with respect to right to property. You had what was called Article 19 Clause 1 Clause F. Article 19 Clause 1 Clause F said that you have the right to lawfully acquire, hold and dispose of property subject to reasonable restrictions in the interest of public and scheduled tribes. Now if you remember Article 19, It has speech and expression, peaceful assembly without arms, form associations, unions, and cooperatives, right to movement, right to residence. Then it had right to property under 19(1)(f), and then you had the right to profession, occupation, trade, and business, which means you had the right to move anywhere in the country you want, settle down anywhere in the country you want to, and one of the ways to settle down is to, of course, have a property. And the only restrictions that were given was in the interest of general public and scheduled tribes. Scheduled tribes largely because you would effectively have them to be very involved and would have a greater intersection with their ecological surroundings necessary for their survival. And the interest of general public could be interpreted as land reform, could be interpreted as land acquisition, and so on and so forth. Article 31 originally had Articles 31 Clause 1 and 31 Clause 2. Articles 31 Clause 1 basically spoke about how nobody could be deprived of their property except by an authority of law, and by the executive action, the state can acquire the property of any person by paying them market value. So while land acquisition was allowed only by paying fair market value. And nobody could deprive a person of their availability or their authority over property. And 31 Clause 2 was a very interesting provision, which was also later adulterated, is that the state can only acquire the property for public purposes, and the state should therefore pay compensation. The Land Acquisition Act of 2013 also tends to solve the similar purposes. Now, in these original provisions of Articles 19(1)(f), 31 Clause 1 and 31 Clause 2, a several bunch of changes have happened over a period of time. So, my original text of the Constitution says this. I have Article 19 Clause 1 Clause F, I have 31 Clause 1, and I have 31 Clause 2. There are going to be certain changes that will be made to this particular set of provisions. The first set of changes are made by the first constitutional amendment of 1951, which we've already discussed, where 31A and 31B are added to Article 31. This was in response to the land reform acts that were being challenged at various high courts and then were effectively being put in the 9th schedule. So Article 31A basically put a blanket stop to all of this. It said, if there is a law that is being made to acquire large estates from zamindars, it will not be invalid and it will not be a violation of fundamental rights under 14 and 19. So basically a fundamental right will not be violated if land has to be acquired. And 31B basically added the 9th schedule and made anything in the 9th schedule to be judicially immune from judicially reviewable. And one of the most additions, the largest number of laws in the 9th schedule are in fact land reform acts. So 31A said no fundamental right violated in case of land acquisition. And 9th schedule was inserted where land reform acts were added, making them immune from judicial review. Through the 4th Constitutional Amendment of 1955, a small change was made to Article 31 Clause 2, wherein it was mentioned that compensation cannot be challenged on the ground that the compensation is inadequate. And the court did, and eventually the court looked into it and the court said the compensation at the end of it all should be fair and just. But the contestation of compensation will no longer be an issue. What you would be looking at is a larger term called amount. Then the grand change happens in the 25th Constitutional Amendment of 1971, where through Article 31 Clause C, a new article that is added, we've discussed this umpteen times, 39B and 39C, therefore tend to be greater than Articles 14, 19 and 31. Now, this, as we discussed before, has an impact on property because equal concentration of wealth and distribution of resources is well executed through land reform. Through the 44th Constitutional Amendment Act of 1978, Articles 19 Clause 1F, 31.1 and 31.2, they were effectively completely repealed. And provisions of Article 31 were moved from Part 3 and placed under Article 300A. And that's how the right to property became a constitutional right and a legal right. Why I equate constitutional rights and legal rights is because their enforcement mechanism is more or less the same. In case of a violation and there is no other alternate legal remedy available, then what generally happens is you can go to the High Court for it. Which then brings me to a larger question, which is, how has India dealt with right to property as a whole? The evolution of right to property as we understand it to be. See, the Constitution of India, as we know it to be, owes its origin largely to the Government of India Act of 1935, where significant provisions were imported lock, stock and barrel. But the idea is, even during British time, land was a very, very key ingredient of British policy. And therefore, land became one of the key reasons for turmoil against the British and policies which are exploited in the favor of the British. In fact, not only does the Government of India Act of 1935 have a reference to property, the Universal Declaration of Human Rights, which is one of the world's foremost global instruments on human rights of 1948, does also have a mention to the right to property. If I remember correctly, Section 299 of the Government of India Act of 1935 did actually try to protect the right to property against any form of inappropriate expropriation, which included compensation, etc., etc. I think it was Article 17 of UDHR and 299 section number of the Government of India Act of 1935. Now, the Universal Declaration of Human Rights also recognizes property as one of the most important rights for the fulfillment of a person in India as a signatory to that declaration. The makers of our Constitution, the Constituent Assembly, carefully examined the status of property across various countries, examined the nature of property and juxtapositioned it to the nature of the economies of the countries. The nature of property in a developed economy versus a developing economy would be entirely different. The nature of property in an economy or a political economy which has a socialist bent of mind would be radically different. And therefore, you had to provide some form of property in the form of a right to our citizens, and at the same time balance socialist interests. There generally is a lot of misunderstanding about the scope of the right to property under the Indian Constitution. The idea here is to understand that right to property is not only reflected through these provisions that I've discussed, but it also has a manifestation in India through Articles 14, 19, and within 19, Articles 19 Clause 1F, 19.15 would also have a implication to 31 and 32. Right to property would also have reflections in Article 39B, in Articles 39C, Articles 226, effectively Articles 265. These are a list of provisions in the Indian Constitution which would therefore have an impact. And agrarian reforms in India have also had an impact on sort of property rights. When we look at these agrarian reforms, we would generally understand now this also has an impact in GS paper 3, intermediaries were abolished, a ceiling was often fixed on land holdings, the cultivating tenant within the ceiling secured certain amount of permanent rights. In fact, in some states, the share of the landlord was also regulated by law. In some states, in fact, in one specific state, the tiller of the soil had cultivating rights against the absentee landlord. And in some states, the rural economy was readjusted in a way that the scattered bits of each tenant, the scattered bits of land of each tenant, were then consolidated in one place, and then there was a statutory exchange of some kind. And these agrarian changes therefore had an impact on the legal policy of land and property. And therefore, there are some basic proposals that could be identified. That each citizen has the right to hold property. The state can impose reasonable restrictions on the same. The state can take away your right to property if there is a need for it. And for that, the state is entitled to pay you a fair market compensation for it. And if the compensation which is set by law is rather illusionary in nature, then you can always have some amount of judicial challenge onto this. So, in some form or another, there has been a lot of work that has happened in the context of these property rights. Now, the idea is to understand why all of this happens. We discussed Article 31C basically protects the laws that ensure material resources of the community are distributed to serve what is called common good. 31B very categorically says, in a very simple manner, that the distribution of resources should be in common interest and should not be towards the detriment of a certain commodity or a certain community. So Article 31C therefore very clearly said 39B and C is greater than 14, 19 and 31. 31C, as we understand, was introduced by the 25th Constitutional Amendment of 1971. And the reason why 31C was introduced actually becomes important in our understanding of right to property. 31C was introduced by the 25th Amendment of 1971. Now understand this as carefully as we can. The 25th Constitutional Amendment of 1971, which introduced Article 31C, which gave 39B and C greater superiority towards 14, 19 and 31, was done in response to the bank nationalization case. Now, the idea behind the bank nationalization case is a very, very simple idea. What had basically happened was, in Rustamji Cooper versus Union of India in 1970, the Supreme Court had delivered a judgment against the bank nationalization policy as far as the government's bank nationalization policy was concerned. Now, basically, the Supreme Court had struck down or stopped the center from acquiring control of 14 commercial banks, which the government wanted to do by enacting something called the Banking Acquisition Act of 1969. And this 1969 Banking Acquisition Act was effectively narrowed down by the Supreme Court. Now, 11 judges sat down for this particular case and struck down basically this particular aspect and therefore looked at Article 31 Clause 2. If you remember, Article 31 Clause 2 said that the government could not acquire any property for public purposes. And therefore, unless the law fixes compensation for that kind of a property or specifies the principles on it. So Article 31 Clause 2 was very categorically. Now, this 11 judge bench while struck down the Bank Nationalization Act because this Bank Nationalization Act was violating Article 31 Clause 2, which basically had said that the state can acquire property for public purposes only if there's a compensation principle involved, and there was no strict principles of compensation that were given. As a result of this, the Bank Nationalization Act was therefore struck down. Now, having said that, the case therefore eventually happened to lead to a larger issue, which was that the right to compensation, which is a very important aspect of the acquisition of property by the state, was not adequately done by the Bank Nationalization Act. So that is how 31(2) basically became a deterrent to 39B and C, superior to Article 14 and 19. And this 25th Amendment was effectively then challenged in the Keswanand Bharti case, and the non-judicial review component of it was therefore struck down in the Keswanand Bharti case of 1973. Now, 39B and C still continued to be superior to Articles 14 and therefore 19. And then in the Minerva Mills case, where further provisions of 42nd Amendment of 1976, which had given superiority to all directive principles over fundamental rights pertaining to 14, 19 and 31, and no judicial recomponent, the Minerva Mills case brought it back to the pre-42nd position and struck down the no judicial review part because of the amendments that were mentioned. Now, since then, and since 1977, the Supreme Court has generally weighed on the interpretation of Article 39B. And therefore, what is meant by material resources, what is meant by concentration, what is meant by common detriment is often dealt with when it comes to this larger issue of acquisition of property. And this is why it becomes very, very interesting in largely deciding whether the Supreme Court will make a final call on whether the government can acquire private property under Article 39B. So that is something that we must always keep into mind. Now that we understand this in that context, let us now try and figure out exactly what is it that we're trying to achieve through all of this. The primary purpose or the primary understanding of the right to property case is actually a case of directive principles and its enforcement. The case is called the Property Owners Association versus State of Maharashtra. As we understood, the story basically starts with Article 39B because it mentions two very important words: ownership and control of material resources of the specific community in a way that they serve what is called common good. So, in the garb of Article 39B, can the government acquire private property? This therefore becomes an issue, especially when post-Minerva 39B and 39C is greater than 14 and 19, and right to property is no longer a fundamental right. Everything is a game of interpretations. In 1977, a 7-judge bench of the Supreme Court with a majority of 4:3 in the Supreme Court case of State of Karnataka versus Sri Reddy very categorically got into this. This judgment was about the constitutionality of a Karnataka law called the Karnataka Contract Carriages Act of 1976. This law was supposed to make sure that all contract carriages in Karnataka were to be acquired by the Karnataka state government. and therefore it largely became an issue of Article 39 Clause B. And therefore, the court held that private resources are not to be in the ambit of Article 39B. This was the majority view. But the minority view, which was headed by Justice Iyer, held to be the opposite. And it is this minority view which has now come back to light in Article 20 in 2024. Approximately 5 years later, in 1982, a 5-judge bench of the Supreme Court was looking at something at a very similar matter. And in 1982, a 5-judge bench of the Supreme Court, in the case of Sanjeev Coke Manufacturing Company versus Bharat Coking Limited. So it's basically Sanjeev Coke versus Bharat Coke. The court got the opportunity to examine this all over again. It is in this case the court was looking into the constitutionality of 4 central laws that were passed between 1971 and 1973 for the nationalization of various coking coal mines and also non-coking mines. And the idea was it was not just mines but also even coke baking plants, coke oven plants, and owners of these had challenged these legislations. The court in this case affirmed Justice Iyer's view that private resources actually could be the way to go when it comes to government acquisition, because that is the true nature of socialism. Many years later, in 1997, a 9-judge bench in the Mafatlal case, which was led by a Chief Justice at that time was Chief Justice Ahmadi. The case was about whether there can be a claim of a form of a refund of a certain kind against an unauthorized levy of certain tax. Actually upheld the view in Sanjeev Coke Manufacturing and said that basically material resources also included privately owned resources and it was not confined to public resources. So it is in this context that the Maharashtra landowners case happens. Now, what has all of this to do with the Maharashtra case? What happens in Maharashtra actually happens in 1986. The state government of Maharashtra amended the Maharashtra Housing and Area Development Act called the MHADA Act of 1976. And the Maharashtra government added a new chapter to the MHADA Act called Chapter 8A. This basically allowed the Bombay Building Reconstruction Board, and it's a proper board set up under the government, to acquire certain properties for restoration purposes. And you would be able to do that if 70% of the residents of those properties consented to such a restoration exercise. And Section 1A, which was introduced in that amendment, basically wanted to do this for the implementation of the principles of Article 39B. So the MHADA Act wanted the government to acquire properties for restoration purposes, fulfilling the objectives of Article 39B. Now there's the Property Owners Association of Bombay, which comprises of more than 20,000 landowners in Bombay. They first filed a petition in 1991. This petition was filed challenging the amendments that were made to this MHADA Act. They said that this Bombay Repair Board has been given too many powers. It's too gigantic for us to control. And therefore, it would effectively mean that this Bombay Repair Board would take forceful possession of these complexes. In 1991, the Bombay High Court dismissed of these petitions. And the court therefore reasoned that the government was duty bound to protect shelter to its people. And they says that both, and they very categorically said that there is Article 31C, which says 39B and 39C are greater than 14, and 19 and 31 no longer is a right to property, so is inconsequential. So the government is implementing a directive principle. Your house owners cannot come and challenge it. Now suddenly there is a conflict in 2001. A five-judge bench in the Supreme Court, in the five-judge bench, which was hearing the Property Owners Association, they said there is a conflict between the Ranganath case in 1977 and the Sanjeev Mafatlal cases, whether private property comes under 39B or C. And therefore, in 2002, this case was referred to a larger bench, a larger 9-judge bench. And they found that there were issues with the Mafatlal case, and the Mafatlal case had to therefore be reconsidered. All of this now has been tied up to the Supreme Court, and from October 2023 onwards, there have been grand arguments around it. Whether private property is actually included under Article 39B or not. Now, barring the technicalities apart, what is this case really about? This case is about whether you are more socialist than you are more market friendly. If you just read the text of Article 39B, it says you can redistribute resources for common good. Now, does that mean resources also includes private resources? Especially in a country where right to property is no longer a fundamental right, and therefore there are several restrictions. So the way forward to this would be, whether the resource is public or private, the government can acquire it as long as the basic structure of the constitution is upheld, which means the essence of fundamental rights is upheld. As long as you can answer that in this manner, you are absolutely sorted. And that finishes the first half of theme 2, which covers the lectures that we wanted to. See you in the next lecture. Thank you.